Cannot or judgment.
We have mentioned made please, your lordship. With regard to item number 4 of today's list, maybe
There's a judgment. Appeal is dismissed.
Lord, with your lordship's indulgence, I would like to mention item 3. Lord, we are supposed to file our written argument, which I could not complete it. So can your lordship accommodate us with 2 weeks' time?
2 weeks.
Within 2 weeks, I'll be filing.
You will not be there, no? I'm not there.
Whether this bench is there or not, it's not material.
Probably lordship is not here.
Just for filing, minute, we can file.
Okay, item 3 on request made by Mr. S. Datta and the senior counsel for the petition. List after, for the applicant. List after 2 weeks.
Minute,
Just
when,
take 2 weeks.
as when your lordship is available, that order. Much of it.
made please, your lordship. With regard to item number 4, lordship, I have some personal difficulty to appear on behalf of CBI in this case, lordship. I intimate the fact to the CBI, lordship, and process has been initiated to appoint new lawyer. So maybe taken up after 4 weeks, lordship.
Your good name?
M. Haloy, Manos Haloy, retainer counsel CBI.
Okay, on request made by Mr. Manas Aloy, regional counsel CPA, Mr. Mehta after 4 weeks.
4 weeks, lordship.
After 4 weeks.
Value.
Well. Lordship, with the consent of the other side, I beg to mention item number 6. Lordship, Advocate General is the special counsel appointed for NIA. So today he is engaged in some other urgent matters. So Lordship may kindly fix the matter after summer vacation.
After 1 month?
If the Lordship may fix on 18th of July.
Okay. 6 on request made on behalf of Mr. D. Saike, Advocate General,
Yes, Lordship.
Assam. Appealing for the applicants. List the matter. When?
18th of July.
18th of July.
Obliged, Lordship.
Item 1 and 2 of daily list, admission, partner method.
May please, your lordship. Lordship, today I have to give my rejoinder. Last time, my lord, the State Council has completed his submission to reply to my submission, your lordship. So, my lord, if the respondents have something to say, my lord, let them. Otherwise, my lord, after I complete my rejoinder, then if they started submitting something, then I have to reply it back. Then it will be never ending, your lordship.
No.
There was an intervener in this case, isn't it?
No,
No, my lord.
There's an intervener.
no. Because almost, my lord, I have completed my argument, my lord.
You
And then,
completed-
yes, my lord, and then your lordship, my lord, I have repeated certain areas of facts. And your lordship was stating that, no, we have heard. Lordship might have been remembered, my lord, your lordship. So therefore, my lord, as far as my concern, my lord, I have completed all the factual grounds and laws. And in respect of the state also, my lord. So, my lord, let my colleague, a good friend, may submit.
Yes,
Why,
yes, yes.
why he is submitting that we rejoin that this and that, my lord? If there be
No.
requirement, I won't take time because let him submit independently. This is not the way.
No, this is because, my lord, I want the
Wait, my lord, let
method
him
to be
submit, my lord.
completed today, my lord, my submission, that's why. your
Let
lordship.
him commit,
No, no,
and that, my lord, we have I mean, submitted the written argument and I have received the
Yeah.
written argument from my good friend, my lord.
Yes.
Let him submit, my lord, independently. Why should my lord this type of submission? Let
But
him
my lord, the experience says this. It happens many times. That's
Yeah.
what, my lord. Yes, may I? So, my lord, I won't take much time today, my lord. Whatever I have to submit, I have already submit earlier. Your lordship. Yes, our decision.
My lord, for me also.
Yes. My lord, some of the points, my lord, which I think necessary to give a rejoinder after hearing their
AC is working on. Yes.
Yes, my lord. So, my lord, last time, my lord, when I filed the additional affidavit, your lordships, my learned friend has an objection saying that we didn't take the leave of the court. Even though, my lord, I have shown to this honorable court that, my lord, we have taken permission of this honorable court and filed it, the additional the affidavit, your lordship. And, my lord, apart from that, my lord, my learned friend pointed out regarding the CPC. But section 141 of SCPC clearly says that, my lord, is not applicable in the case of writ matters, your lordship. So, my lord, may I read it out, your lordship? 141, miscellaneous proceeding. The procedure provided in the court in regards to suits.
Huh? Yeah, is it necessary to go through?
No, man, I'm just, my lord, pointing out, your lordship, my lord has accepted my additional affidavit, my lord, I bow down, your lordship. But yes, my learned friend pointed out last time that is there is some objection, technical objection. Just pointed out that it doesn't cover. 226 doesn't cover by the CPC, my lord, proceeding. So, my lord, it started from 226, that's why it can be submitted. That also, my lord, is granted by this honorable court, your lordship. This I wanted to point out, your lordship. I bow down. Mm. Mm. In fact, my learned friend said that there should be an application for. Then it's requesting, praying for that, my lord. That, yes, ma'am. I'm proud of it. So, my lord, coming back to this, my lord, the question of my lord, this amalgamation, your lordship. Why there are objections that we raise these issues in this appeal, your lordship. And we have last time also, my lord, submitted to the honorable court that after we've received this information through RTI, we had filed another writ petition also challenging that immediately, my lord, that's amalgamation. And the matter is pending, your lordship, my learned friend also pointed out. And, my lord, another point, why did amalgamation has been, my lord, can be raised in the appeal is this, my lord. Even though in the writ petitions, my lord, that amalgamation matter was silent, the honorable single bench, while deciding and disposing of the writ petitions, dismissing my writ petitions, allowing the writ petition, came and decided and concluded a finding saying that the amalgamations regarding the respondent is correct. At para 44, loss. Para 44 of this judgment. WA 27. 27. 11 para is
44.
page number 35 by 42, your lordship.
Is it appeal?
Is it appeal? 27, your lordship. Hold on. Hmm.
Para?
Para, my lord, para 44 last line, your lordship, just the, and the top of this page number 35 by 42, internet page 41, your lordship. In case on hand, Hockey Manipur has fulfilled the provisions of section 12 of the Act of 1989 and accordingly got registered. And section 12 of the Act is regarding amalgamation process, which we are submitting to the Honorable Court that they never, my lord, followed the provisions, your lordship. So, my lord, the finding of this London single bench initiated my lord and necessitated by me, my lord, to raise this issue of amalgamation, your lord. So, my lord, today, yes, ma'am. So we, my lord, today, my lord, the other party also cannot say that we cannot bring that issue amalgamation. Because if they are saying that the issue was never considered in that writ petition, then it'll be wrong factuals. Because learned friend, so single bench, my lord came to the conclusion that, man. That's why, my lord, in the beginning of my submission, the last time, my lord, I was praying to his honorable court that if possible, the matter can be remanded back and to hear along with this amalgamation process, your lordship. Tomorrow, suppose, my lord, my writ petition is allowed out there, saying that the amalgamation process is not followed, then it will be, my lord, chaos in that state of Manipur regarding hockey, my lord. There won't be any, my lord, associations to look after the affairs of hockey. Because in one hand, I'm directed to change my name, and apart from that, altered my memorandum of association. At the same time, the other association who is claiming that they have amalgamated to run the, my lord, the game of hockey, you won't be there, your lordship. Then, my lord, let me take to your lordships to section 12 of the Act and section 15 of the rules regarding amalgamation, your lordship. Act is switched.
Are you replying or are you going fresh again?
No, my lord, I'm just pointing out the point that they have raised. Because they have raised these issues, your lordship. So I'm just, my lord, clarifying it, your lordship.
Who?
Yes, section 12, your lordship, of the Act.
Section 12.
Yes. Yes, madam. Society to have power to amalgamate with another society. Whenever two or more society desire to amalgamate, the governing body of each society shall submit a joint proposal writing to the registrar for his prior approval thereto. No such proposal shall have the effect unless the proposal with the modification, if any suggested by the registrar, is confirmed by the 3/5 of the joint members of the society is concerned, and appeal shall lie to the state government against any order of the state government to such appeal shall be final, my lord. So, my lord, my humble submission is, your lordship. Apart from this issue where we have raised this, because they never applied for the registration of the amalgamations to the concerned authority, they just gave an application to the state, to the minister. Cooperative, my lord. That's why we said they haven't followed the process, and there was no formal, my lord, these things. This thing, my lord, meetings and all. Until today, my lord, after we have pointed out all these things, they haven't approached the concerned authorities. Then, my lord, kindly come to the rules. This is more clear regarding amalgamation, your lords. Rule 15. My lord got the rules, your lords. Rules of 2004. 15 years procedure to amalgamate with another society under section 12. The societies intending to amalgamate shall discuss the proposal for amalgamating the societies in separate meetings of its governing body of the societies, and resolutions shall be taken to the effect that the societies be amalgamated as per the provisions of the Act, Your Lordship. This was never done, Your Lordship. Before having a joint meeting, the separate associations or society they must have individual meetings, Your Lordship, resolving that yes, we want to resolve amalgamate with another association, then we have to proceed with that. It was never done. And my lord, 5, Your Lordship, on the receipt of the approval of the registrar of society, the proposal shall be discussed in the joint general body meeting of the society called for the purpose. It was also never done. And apart from that, my lord, publishing in the register gazette and all these things in that other clauses. Yes. All procedure, my lord, laid down for the purpose, Your Lordship, was never followed. That's why my lord, last time my lord, we have submitted, my lord, that the amalgamation process was wrong. Completely wrong, is against that, my lord's procedures. Yes. On the face of this, my lord, the finding of learned justice is incorrect. Then matter should be, my lord, either discussed or remanded back, my lord. And in the interest of justice, even apart from my lords, I submitting that the matters that the impeachment judgment should be called. I am just submitting that matter of remand back to hear it together, to close that issues one go, Your Lordship, for good. Otherwise, my lord, that the problem of my lord players in the money in that my lord state of Manipur regarding the hockey, my lord, it will be a huge problem, Your Lordship. For example, my lord, today all the my lord tournaments and other my lord players who have participated as a in the international tournament as a member of Indian team are through this appellant only, my lord, Manipur hockey. If Manipur hockey goes away, then what happens to those, my lord, award, everything, my lord, which they have earned? And apart from that, my lord, as I have submitted earlier, my lord, we are the only associations recognized by this, my lord, Olympic associations and affiliated to the Hockey India. These are the issues, Your Lordship. So, my lord, the issues, whether like we have no, my lord, the objections and my lord, problem which both the societies or associations have come together and make one. And my lord, regarding my regarding that impugned order of the state government, which is upheld by this honorable learned single bench, Your Lordship, single judge, saying that there is a similar name, then on that ground also, my lord, my humble submission is, Your Lordship. As Your Lordship has been like pointed out by learned friend who is appearing for state government, my lord, in his the two, my lord, affidavits, completely they contradicted affidavit, my lord. In one affidavit is saying that by mistakes and by overlaps, register was given to us, even though, my lord, I have pointed out last time, my lord, it was done, my lord, after the thorough inquiry by the officials of the state, Your Lordship, not by any private individuals, and they have cleared my name. And in that report itself, my lord, last time we have pointed out, they said that Hockey Manipur never applied for registration at that point of time. They haven't submit anything. And my lord, in the affidavit prepared by my learned friend himself, in Anand Beer, there are two petitions, Your Lordship. And in the petition, he himself said that, my lord, we are given the registration by a thorough inquiry. Completely contradictory, Your Lordship. And the affidavit, he was by himself, Mr. Athoba. In that he accepted that it was, we have with proper, my lord, investigations and inquiry, Your Lordship. So, my lord, the stands of the state government service, my lord, where they stand, it is very confusing. They have two stands now, my lord, in the same matter. And I'm not just saying this because it's on affidavit, it's on what they have given it. It's on record here. We have pointed out in our the recent submission, Your Lordship. This is the issue, Your Lordship. And my lord, regarding this rule, Section 10 regarding that, my lord, on that ground, my lord, I have been directed to change the name, Section 11, to change the name, and my lord, to alter my memorandum associations, my lord, my humble submission it is, Your Lordship. When we applied for registrations, and when that authority had its, my lord, inquiry, at that point of time, my lord, the two associations, other associations, Manipur Hockey Associations and Women Association, they have taken a plea and they have resolved that there will be amalgamated to a new associations and surrendered their, my lord, registrations, Your Lordship. So whether, even though, my lord, the whole argument in submission, the main point is this Manipur hockey is similar to hockey Manipur. They never said that Manipur hockey is similar to Manipur Hockey Association and Manipur Women's Hockey Association. They always say that Manipur hockey is similar to hockey Manipur. But my humble submission for the kind concerned honorable court is this: at a point of time, my lord, these two associations have surrendered, rightly or wrongly, Your Lordship, whether it's as per the provisions or not, they have surrendered their registrations, my lord. Whether their name is similar to me, is insignificant, Your Lordship, because they want to surrender. And at the same time, that Manipur Hockey was never registered. And the objections given by Manipur Hockey was an objection by unregistered associations, Your Lordship. So, my lord, my humble submission today is, Your Lordship, if any direction is to be given by the state government, is to be given to the other associations. That yes, another association is already there, Manipur Hockey Association, so you have to change the name. Or, my lord, yeah. Yes, my lord. Then objections are, my lord, we have already pointed out in written submission also. In read petition number 27, my lord, 23 PS number 2110 to 120. I have last time I have shown, Your Lordship. No need to repeat again, Your Lordship. So, my lord, these are the objections, not from those earlier associations, by the objections from an unregistered association, which is going to be registered in future. So, my lord, as Manipur Hockey has already registered earlier, giving it all registration number, nobody can claim that, Manipur Hockey has a similar name with Hockey Manipur. In fact, Hockey Manipur cannot be given the name because Manipur Hockey is already registered when they have been given register. This is the issue, Your Lordship. So, my lord, yes, my lord. Apart from that, my lord, we have pointed out some of the case laws, my lord, in the recent submission also regarding delay and lashes. Because delay and lashes, why we have taken this ground, Your Lord, because, my lord, even though we have been registered in 2009, the order, impugn order by the state government is 2018. Must after 9 years, Your Lord. And 9 years we were running the show, my lord. Running this affairs of this hockey, my lord, producing international players after international player, Your Lord. And my lord, my humble submission is one aspect is, Your Lordship. Even though those two associations now claiming that they have formed an amalgamation, a new association, many of their members, especially those international players who were there in that those associations, they have joined us. They are running this, my lord, Manipur Hockey today as a member, Your Lordship. And as a member and a very, my lord, active member, Your Lordship. And my lord, case law, my lord, 2001 to SEC 259 para 7 and 8, my lord. This is, my lord, the delay and losses, my lord, paragraph. Is it? No, nothing. Then, my lord, I won't get much time because your lordship, and another, we don't, my lord, tried much judgment, your lordship. And 1976 to SEC. And regarding this, my lord, if the provision is there, your lordship, it should be followed correctly, your lordship. The provisions cannot be, my lord, probably override, flouted, or my lord, yes. This is not all. Who comes in? 7623. Taman. I can press again. Then, my lord, 1999 3 SEC 422. We have, my lord, cited in that, in the written submission also, my lord. This is, I pray, para 31, my lord. I will just read it out, just 2 lines, your lordship. It's the basic principle of law, long settled that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. The origin of this rule is traceable to the decision of the Taylor versus Taylor, which is followed by the Lord Rochi in Najir Ahmad and King of Emperor, who stated as under your lordship. So, my lord, my humble submission is their lordship. The manner in which the amalgamation has done, as is against the procedure, against the act, against the rules, it cannot be done at all. And my lord, last time also we have pointed out, your lordship, even today, after the so-called amalgamation, my lord, through RTI, we came to know that they haven't filed any, my lord, yearly statement of these things, my lord, general body meetings, statement of, my lord, income tax, statement of anything, my lord. In fact, the association is running, my lord, in paper, not actually they're running it out. So, my lord, all that we are praying is this, my lord. By seeing that, my lord, the problem which is going to be faced by the prayers in Manipur, especially hockey also. I hope that my lord will, my lord, definitely, my lord, accept my submissions, and either, my lord, remanded back the matter to discuss the issue amalgamations along with this issue, other issues, your lordship. And 1976 also, my lord, it says that it is well settled that where a power is required to be exercised by a certain authority in certain way, it should be exercised in that manner or not at all, and all other modes of performance are necessarily forbidden. So, from in any form, my lord, it cannot be done, your lordship. Very. And one, my lord, last time my learned friend has pointed out regarding one letter written by that Registrar Cooperative Society to the Deputy Advocate General, my lord. And that learned single bench was highly relying on it to dismiss my request. But my humble submission to the lordship is, this is completely contrary to the records available in that office, your lordship, of the corporate society. And completely, my lord, contrary to that, my lord, this inquiry report. And it's, my lord, it's all, my lord, this letter is, my lord, it's not based on actual facts, my lord. And my lord, it is has some sort of, my lord, hidden agendas and biased motives. Because, my lord, the inquiry reports speaks otherwise, and he has written something it speaks otherwise. And, my lords, and one thing which we failed to this, we could not file it affidavit challenging, countering it, because it was produced in the flag end of this argument before single bench. So, my lord, there was no time for that counsels appearing for that, they, my lord, to counter it also, your lordship. And apart from that, my lord, last time that after going through that, my lord, the reports, the council appearing followed my predecessor, my lord, who appear in that single bench, before single bench, my lord, he submitted verbally, but it was never, my lord, reflected in the judgment. Even whether accepted or not is different thing, my lord. It was never reflected. Mr. Prana was appearing, my lord. Mm. 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 So, my lord, in that justice and fairness, my lord, my humble submission is your lordship, my lord, whether matter can be, my lord, remand back, or it can be quashed. But still, my lord, my learned, lords think that, you know, the wisdom of lord thinks that, you know, it can be remand back to hear it afresh. Even this matter, your lordship, yeah, we are ready. In fact, the perpetuate, my lord, illegality, which is carrying on, my lord, regarding the amalgamation, should not be accepted and cannot be accepted by the honorable court, your lordship. Because, as I have pointed out, as demonstrated, everything was irregular and illegal, your lordship, as per the rule and act, your lordship. So, my lord, apart from this amalgamations, my lord, and my lord, apart from my the registration and changing the name of my associations, my lord, as I have pointed out, my lord, it is not me who has to change the name. It is the respondent, Manipur Hockey, has to change the name, your lordship, because Manipur Hockey was never existed when I'm registered in the state of Manipur as the, my lord, the only association who was looking after the affairs of hockey Manipur, your lordship. So, my lord, I won't take much time. This is just a rejoinder. I just pointed out a few things which I think, my lord, it will be sufficient enough, my lord, or necessary enough, my lord, to point it out, my lord, just from the facts and laws which my learned friends have pointed out also. And, my lord, the rest of the, my lord, these things, there's a citation of cases, your lordship. I think, my lord, few of these citations which I have submitted to your lordship are just, my lord, to help your lordship to decide this matter. Otherwise, my lord, for me, my lord, your lordships are the living encyclopedia of judgment, your lordship. I have nothing to do with it. You know better than me, your lordship, what should be the case law which should be applied on this. And that regarding my learned friends, my state councils, his submission, my lord, they have not taken any, my lord, clear stand regarding this, your lordship, till today. Whether we are right or they are wrong, or they are right or we are wrong. So, my lord, all that I'm praying this should be educated, and it can be, my lord, discussed. It can be decided, my lord, permanently, my lord, by the single bench for good, your lordship. I'm completed, lordship.
Yes, this one. Leonard Senior Counsel. Assisted by?
Mr.
Howard Praveen. Howard Praveen.
H. Prabhu.
H. Praveen and A. Kalita.
State Kalita. Leonard Counsel for the. Also heard Mr. Apova Kaita, the additional senior government. For the state response. The Sahiwala also is this?
My lord.
Mr. J.N. Saiwala.
Senior Shaiwala must
Senior
be here.
counsel along with Mr. M. Chandra. Then the senior counsel, assistant Mr. J. Rama, then the counsel for the respond. Hearing continue, just. Yes, sir.
Great oblige, my lord.
Double oblige.
Item 5, hearing.
Is it coming up for us? Huh? Huh? That part of it, oh.
Five,
Oh, this no wonder. None appears for the parties. List up to 2 weeks. Interim order possible to continue till the next week.
R. Messenger for the department.
Hmm.
Kindly adjourn the matter for 2 weeks,
30,
38.
on request made on behalf of Mr. R. Majumdar. Learned counsel for the petition. Learned standing counsel elementary education
My lord,
for the petition. List after.
2 weeks, my lord. Offline.
May I please?
Uh,
I beg to mention listing a motion matter on Friday, my lord.
Why Friday?
Urgency, my lord. Selection and appointment of assistant professor. Matter, my lord. On Friday, oblige.
May I please, your lordship? Chief, I beg to mention item number 8, your lordship, with the consent of other parties, your lordship. Only this matter may adjourn for today
You are for?
and for the petitioner,
Your good name?
R. Chetri,
You are appearing on behalf of?
Mr. P. Sharma.
On request made on behalf of P. Shah. Learned counsel for the petition. List where
After 2 weeks, lordship.
after 2 weeks.
Oblige.
So may it please, your lordship, I beg to mention item number 16, lordship.
16.
Yes, lord. So there is some personal difficulties of my senior to say something. Which may take it upon 4 and
Who's your senior?
the BD code. Senior counsel.
For the respondent,
Respondent number 7, Lordship.
have you taken the consent of petitioner?
Every time not six lordship, 6 or 7 lordship.
You are applying for the petitioner.
No, he is appearing for the petition.
Yes, I'm
Heard, Mr.
MBS hot lordship.
Is Hawk Learner Council for the petition. On request made on behalf of Mr. P.D. Gonwal and the senior council. For respond number 7. When do you want?
Fourth,
Huh?
Maybe fourth lordship.
4th of?
June. Tuesday. Okay. Apply.
Lordship.
May it please the lordship. Lordship, item number 39, I am for the petitioner, lordship. With the consent of others, sir, this matter may come after 2 weeks, my lord.
Okay, on request made by Mr.
R. Karim,
R. Karim Learner Council for petitioner. List of two.
oblige the lord.
May please your lordship, I beg to mention for listing of an item for orders, lordship. I for implement on Thursday, lordship.
Oh, this coming Thursday.
Lordship,
No. For implement,
lordship,
you'll have it on 4th.
fourth. Much obliged, lordship.
May it please lordship, I beg to mention item number 2, lordship. So the conducting council, Mr. Free has some health issues today, so he could not come, lordship.
Who's the conducting council?
Mr. A. R. Priya, lordship.
So when do you want?
Lordship, any date after 1 week, lordship.
Okay, on request made on behalf of ARPN Learner Council for petitioner, list up to 1 week.
Lordship, kindly, if need
I'm
date,
not fixing date. You are
No.
telling the matter.
only lordship.
May I please your lordship,
Uh.
we have filed an affidavit in reply in item 23. It has not come into the record.
Okay,
Lordship may kindly allow to bring it.
that will see. Let it reach.
Okay, most obliged.
Item 1 of daily list, motion.
Huh?
May I please the lordship?
Yes.
My lord, the matter pertains to selection of president of the school managing committee of my lord. My lord, if your lordship peruses order dated 9/2/2024, my lord. 9/2/2024, last but second, third paragraph, my lord, there was a direction by this honorable court that the district elementary education officer Morigaon shall also by strictly complying with the provisions of Rule 13 of the Assam Right of Children to Free and Compulsory Education Rules 2011, proceed to select a person from amongst the parents to be the president of the SMC of the said school and thereafter constitute the SMC. The steps as taken in the matter be placed on record before the court by the district elementary education officer Morigaon. So, my lord, the section 13, my lord, 13 is specifically stipulates that, my lord, the headmaster, head teacher of the concerned school shall convene a general meeting of parents, the adult members of the village, tea garden area, ward, NC area concerned, ward members, councillor, Gaonpura, / village headman, local health worker, Anganwadi workers within 15 days from the date of receiving the intimation from the competent authority to constitute the SMC. She has to give 7 days advance intimation to the concerned invitee regarding the date, my lord. So in terms of this order passed by this honorable court dated 9/2/2024, my lord, the concerned district elementary education officer by communication dated 9/2/2024, my lord. That instruction was on last occasion placed before your lordship by the standing council. 9/2/2024, my lord, communicated to the concerned headmaster to convene the meeting, my lord. But, my lord, in that communication, the proposed election was to be held as shown in the letter. That communication is 13/2/2024, my lord. The letter was dated 9/2/2024, and election was held on 13/2/2024. My lord, that is not in compliance with the provisions of the law because 7 days strictly, my lord, the law says that 7 days notice has to be given. And this honorable court has also directed to comply with the provisions of the said section, my lord.
But without complying that, my lord, a new managing committee has been formed, my lord. And my lord, the petitioner, case of the petitioner is that because, my lord, that by no proper notice was given, my lord. Only, my lord, that in terms of the communication, my lord, with some selected persons, my lord, the president has been elected.
Are you not supposed to challenge that also?
My lord, because I am supposed to challenge, but it is an ongoing process because in terms of the court order dated passed by this honorable court dated 9/2/2024, they have to place the material, my lord, and that material shows that, my lord, it is not within, it is not in compliance with the provisions of the law as well as the direction by the honorable court.
No, that's why. Are you not supposed to challenge that proceeding? That is a requirement.
Yes, my lord. But, my lord, in the ongoing process also, that is a subject matter of the ongoing.
It's an ongoing matter, but then once that decision has been taken, once that election has been taken, selection
Yes, my lord.
in terms of this order
Yes, my lord.
passed by this court, they have
Yes.
not followed the rules.
Yes, my lord.
So now you have to challenge that proceedings also.
Yes.
Correct?
Yes, my lord, I understand. my lord.
You have to challenge it.
Yes, my lord. But, my lord, since that instruction has been placed before this honorable court, which shows that it
No,
has.
that instruction.
my lord, I
has
understand.
been placed before this court.
Yes, my lord.
Now, on the basis of that instruction, now it has come to your notice
Yes, my lord.
that the 7 days proper notice was not given. It was only, I think, 4 days or so.
Yes.
So now you have to challenge that this has not been done in terms of the rules or in terms of Rule 13.
Yes, my lord.
Therefore, this also election selection has to go. It's your choice.
Yes, my lord.
So what do you want to do now?
My lord, let it remain there, my lord. So if advisable, then we'll file. It may be adjourned, my lord.
You want to adjourn it?
Yes.
Okay. On request made by Mr. D.B. Bora, learned counsel for the petition. When do you want? List after?
After 2 weeks, my lord.
My lord, it is basically elementary matter, so in the causes, only secondary standing council is reflected, but in elementary education
This
not
stay is also
reflected.
directed to reflect the name of the standing council elementary education in the process.
All right.
3, stay vacating application.
In this case, the department was directed to produce the minutes, my lord.
May I
One
check
minute.
That should kindly some time, maybe allowed, madam. I have not received that instruction. Do you have any time available? I have received instruction from the DU.
Who is Deka?
Eka could not come, my lord. He informed me, my lord, because they have time. They will take time, my lord. They have-
Okay, on request made by MS N. Fukan, Council Elementary Education Department. List the matter when?
2 weeks, ma'am.
After 2 weeks.
The date may be fixed.
List the
Yes,
matter
ma'am.
on? It's up to 2 weeks. It's going to be 13th.
Interim order passed, sir.
Interim order passed in the main reach petition to continue.
Deeply obliged.
4 and 5, admission.
Wait. Pattern matter, my lord.
Guwahati University.
What university? Your lordship is aware, my lord, of the facts. Pursuant to a valid selection process for an advertisement, I was selected, my lord, as an LDA. And on 25/9/2021, my lord, I was arrested with regard to vigilance PS case number 4 of 2021. And on the same day, my lord, I was terminated with an extremely stigmatic order, my lord. Now, if your lordship kindly turns to my appointment letter for a moment,
No, but where's the other side?
Last occasion also he was not there. Or your lordship can have it after some time. I'll try to contact him, my lord.
Six.
I think this is a part-heard matter. The facts, your lordship, were that was that petitioner was serving as the principal of the Assam Engineering College, and there was a death accident, your lordship, where due to drunken driving, some students lost their lives, and there was a huge public hue and cry. And then, after a public statement made by the CM, the petitioner was sent on forced leave. And then, while he was undergoing forced leave, on the basis of a inquiry report, not a disciplinary proceeding, and internal inquiry, he was transferred, your lordship. Now, we have challenged the order of leave and the transfer order both. The submission of the other side, your lordship, what they submitted last time was that there was a public outcry, and since there was a demand from the students that the petitioner should not continue, and he was held to be liable for the unfortunate accident, that is why he has been transferred. So that itself makes it clear, lordship, that a transfer is not in public interest. Because I was found liable in an inquiry proceeding without completing the disciplinary proceeding which has been initiated against me, I have been transferred. Now the records were submitted before your lordship on the last day. So that your lordship will perhaps go through. There's two issues which I'd like to
Record settle.
record book letter.
Where's Gogor?
He is coming. Perhaps, I do not know what the record says, your lordship, but even assuming that it is very innocuous, lordship, even assuming that it is very innocuous, your lordship, that but the submissions were otherwise. What my learned friend submitted the last time was, since I was held to be liable because of my inefficiency, the accident happened. So that itself proves that yes, it is not in public interest. It is definitely punitive. The two judgments of the Honorable Apex Court, which I like to place before your lordship.
No, you placed some judgments earlier, isn't it?
My learned friend placed them. I have not. Lordship, the first judgment is Ram Iqbal Sharma versus State of Bihar and another, reported in 1993 SCC 504. Now, the issue in this judgment, your lordship, the challenge was to an order of compulsory retirement. There also, your lordship, the parameters are very similar. That the writ court will not go beyond what the order says. If the order has been issued in public interest, then that is it, an order of compulsory retirement. But here, the Supreme Court, your lordship, if I may take your lordship to item number, paragraph number 32, your lordship. Since the parameters are similar, I'm relying on the proposition. On a consideration of the above decisions, the legal position that now emerges is that even though the order of compulsory retirement is couched in innocuous language, paragraph 32, your lordship, is couched in innocuous language, without making any imputations against the government servant who is directed to be compulsory retired from service, the court, if challenged in appropriate cases, can lift the veil to find out whether the case is based on any misconduct of the government servant concerned, or the order has been made bona fide and not with any oblique or extraneous purposes. Mere form of the order in such cases cannot deter the court from delving into the basis of the order if the order in question is challenged by the concerned government servant, as has been held by this court in so and so.
Now, in this matter also, the perusal of the order itself does not say that there had been any imputation made against my conduct. But the attending facts and circumstances as a whole, Your Lordship, right from the date of the accident to the manner in which I was forced to go and then remain on leave, the initiation of the proceedings and a sudden transfer, Your Lordship. That will perhaps show that the entire exercise is inherently punitive, Your Lordship. They could have placed me under suspension, they have not. Instead of doing that, they forced me to go on leave and now they have transferred me. So one more judgment, Your Lordship, on the how punitive transfers are to be interfered with. This is the case of Somesh Tiwari versus Union of India and others, reported in 2009, volume 2, SCC 592. I'm relying on paragraph number 16, Your Lordship. Because otherwise the law is settled that it's a very limited scope of interference. But if it is inherently punitive, then perhaps this judgment might have some relevance. Paragraph number 16, Your Lordship.
Yes.
Indisputably, an order of transfer is an administrative order. There cannot be any doubt whatsoever that transfer, which is ordinarily an incident of service, should not be interfered with, save in cases where inter alia malafide on the part of the authority is proved. Malafide is of two kinds: one, malice in fact, and the second, malice in law. The order in question would attract the principle of malice in law, as it was not based on any factor germane for passing an order of transfer and based on irrelevant ground. That is, on the allegations made against the appellant in the anonymous complaint. It is one thing to say that the employer is entitled to pass an order of transfer in administrative exigencies. But it is another thing to say that the order of transfer is passed by way of or in lieu of punishment. When an order of transfer is passed in lieu of punishment, the same is liable to be set aside, being wholly illegal. Now, this is precisely what I am praying, Your Lordship, in this matter, that if Your Lordship lifts the veil, their actions, Your Lordship, though the last order might be couched very innocuously, it will reveal that it is inherently punitive. Because if what they are saying is true, that I am so inefficient, my transfer to Jorhat, just assuming for the sake of argument it is true, I'll spoil the environment in Jorhat also. So definitely what they are saying, that I am such an inefficient officer, then they should wait for the outcome of the proceeding before taking any action against me. Because I am already under forced leave. So that is my ground of challenge in these two orders, Your Lordship. So the records have been submitted. Perhaps Your Lordship would like to go through and then.
Just I clarify one thing to say regarding my transfer that 2009 to SCC 592 regarding punitive nature lordship. This punishment, this transfer is not a punitive lordship. For punitive lordship transfer, it should be in lieu of the punishment. Anything. That's because your departmental proceeding is still pending lordship. There is no issue of regarding punitive transfer. And lordship, other thing is there lordship, for punitive transfer lordship, the post which was held by the petitioner, it can be deviated lordship. The lordship salaries which is taken by the petitioner, it can be taken. Otherwise, in this case, lordship, he is transferred in the same post, same capacity, same salary, same pay scale,
Let us see the order.
everything.
The order, Your Lordship, will find at page number 138 here.
Last page, lordship. 138, lordship.
The order also acknowledges that I am presently on leave.
Yes.
And lordship, regarding that part in the pendency of the departmental proceeding, whether we can transfer or not, it was already I have placed before this honorable court, the dictum of the honorable Supreme Court lordship in 2011 12 SCC 137 lordship. It's a Registrar General High Court of Judicature of Madras lordship, Narsi Pasi case. Already I am relied lordship, it is clearly covered by this case. This is my humble submission lordship. Otherwise, record is there, my lord may verify everything.
Yeah, I'll see the record.
Lordship.
Have you tick marked?
Lordship, already we have flagged it, lordship. Flag mark. Then lordship, other thing also lordship, not a single appointment regarding mala-fide intention lordship. Nothing is there lordship. That part also my lord may consider. And that was also lordship reiterated by the Honorable Apex Court in time and again lordship. In the lordship SL Abbas case also that is there lordship. Already I am relied lordship. And it is lordship in Kashmir Singh case also there. I am already relied lordship.
I have alleged malice in law, in fact, both.
Okay, I'll see the report. Heard keeping for that, learn about it. Also heard Mr. P. Gover. Then the Standing Council Higher Education. Department. For the response. No other parties are involved?
No.
Hearing concluded. Just one minute.
DPO.
Acknowledgement.
Seven.
May I please ask? Well, this matter is relating to reservation for the post of assistant professor lordship.
Yes, BTC Council.
My lord, BPC Council, Mr. B. Choudhury likes in code number 1, my lord. It will take some time, my lord.
And then next week, lordship, any other day then.
My lord, we take it up on Friday if my lord please.
Not Friday. Heard M. Khan on the council.
4th of June.
On request made on behalf of P. Chaudhary, Learners, Standing Council, BTC. List the matter on 11 and 6. 6 June.
Hello.
Lordship 6, I have some problem, lordship, except 6, lordship.
You are not to date.
Lordship, 11th, lordship.
11th, this court will not be. Anyway, this is not the parted matter, isn't it?
Lordship,
Okay,
not
on 11th.
obliged.
Replacement.
9.
Me please, your lordship. Under the claim of the petitioner is provincialization of his service as a librarian in a college. The affidavits are exchanged. And in fact, matter on the last occasion, your lordship wanted to take up the matter. My learned friend, Mr. Gogoi, was not there. That's why the matter was adjourned. May I improve for final disposal to the matter?
Yes, are you ready? Abdul?
Now, certain dates may be important, my lord. The petitioner was appointed as an assistant librarian in 2010. And he joined in 2010. Date is, my lord, 10/12/2010. He joined as assistant librarian in the college. The college was at that relevant point of time at the Banser stage,
Uh,
my lord.
give the date again.
His date of joining is 10/12/2010, 10th of December 2010.
Joint as
2010,
Assistant?
10/12/2010.
assistant?
Assistant librarian.
Yes.
Then, my lord, he took study leave that was granted, and thereafter he obtained his Master of Library Science. He was Bachelor of Library Science earlier. Then he completed the course, master degree, so eligible to become a librarian. And then, my lord, the governing body of the college decided to fill up the post of librarian. He filed an application for upgradation, and accordingly, governing body, my lord, decided to upgrade the service of the petitioner. Accordingly, my lord, on 28/6/2012,
20,
28,
28.
28th of June 2012, he was upgraded as librarian of the college. Then he also, my lord, obtained his PhD degree. That cannot be relevant. Now, for the purpose of provincialization of the, my lord, services of the teaching and non-teaching staff of the college, my lord, there are some forms to be filled up. Accordingly, my lord, he also, my lord, filled up his form that your lordship will get at page 58. That was in 2019. There, my lord, he gave all these particulars. Page 58. This is, my lord, individual information to be furnished by each employee for the purpose of provincialization. So, my lord, he has declared everything correctly. Present post held, serial number 2, librarian, at a salary of 3,400. Then, my lord, serial number 8, the period of service, as on 1/1/2017. Then, my lord, his educational qualification. In spite of that, my lord, this was filled up on 6/12/2019, forwarded by the principal of the college. With, my lord, all marks is. And then your lordship may kindly come to page 61. Page 61 is an order by which the teaching staff of the college, Jamuna College, my lord, their services were provincialized.
You belong to this Jamunamukh College?
Yes, my lord. I work in that college, my lord.
You were
This-
not provincialized.
This is, my lord, 5th of February 2021. The school college was provincialized. Page 61 is the order provincializing the services of the teaching staff. And, my lord, page 63 is the order of the same date regarding the non-teaching staff. The petitioner was left out. Although, my lord, he fulfilled all the requirement under the act. Page 63 is the order of regarding non-teaching staff, order of provincialization. And 61 is the order of the teaching staff. The petitioner was left out. Then, my lord, one issue that may be relevant is that the Venture Educational Institution Provincialization Act that was amended in 2020, prior to the, my lord, order of the order of provincialization of the college. There, your lordship will find, and it starts at page 65. 66 is the, my lord, this is the act. The Assam Education Provincialization of Services of Non-Teaching Staff of Venture Educational Institutions Act 2018 has been amended. Now, section 1(3), it shall be deemed to have come into force on such date as may be appointed by the state government by notification in the official gazette under subsection 3 of the Principal Act, which shall also include any notification to that effect before the date of commencement of the amendment. Then, my lord, amendment to schedule, section 2,
In the Principal Act, for the existing schedule in respect of degree college, now, my lord, your lordship will find in degree college, that chart, category of institution is degree college, category of post librarian. In each college, my lord, there will be one post of librarian. And my lord, salary, monthly salary for the first 3 years is 27,000 per month. Fixed monthly salary from the 4th year onwards, 30,000. Now, your lordship will kindly read the note. Any librarian who has already acquired the qualification required as per UGC norms and guidelines in force on the date of issue of his/her appointment order. This is important, my lord. On the date of issue of his/her appointment order shall be entitled to pay and allowances equivalent to assistant professor from the date of issue of such appointment order, provided that librarian who acquires such qualification within 5 years from the date of issue of his/her appointment order shall also be entitled to pay and allowances equivalent to the assistant professor with effect from the date of acquiring such qualification as per UGC norms and the guidelines for the time being in force. Now, my lord, this entitles him to get the, my lord, UGC scale. Provided further that the librarian shall be treated as non-vocational academic staff. Now, in spite of this, my lord, clear amendment, my lord, the service of the petitioner has not been provincialized, and that's why, my lord, the petitioner is before lordship. Now, page 68, my lord, the petitioner has annexed a document to show that another person, Manjula Deka, of another college, her services were provincialized with effect from, my lord, this date, 11 January 2021. And my lord, this same treatment has not been given to the petitioner. That is the case of the petitioner. Now, date of provincialization of the college will be relevant, my lord, 5/2/2021. So these are the dates which are relevant.
Date of provincialization?
Is 5th of February 2021.
Of the college.
Yes, my lord, of staff of the college, where petitioner has been left out. Now, the Director of Higher Education has filed an affidavit. Primarily, my lord, two contentions advanced. One is that there is an alternative remedy of appeal that your lordship will find at paragraph 5. That the deponent begs to state that the case of the petitioner is governed by the statutory provisions of the Assam Education Provincialization of Service of Non-Teaching Staff of Venture Educational Institutions Act 2018. Section 8 of the Act deals with the appellate authority. Section 8 of the Act 2018 is set out below for ready reference. The state level scrutiny committee shall be the appellate authority in respect of any recommendation of the district scrutiny committee, and the state government in the concerned administrative department shall be the appellate authority in respect of any recommendation of the state level scrutiny committee. As there is a statutory remedy available to the petitioner under the Assam Education Act 2018, this writ petition preferred by the petitioner is not maintainable either in law or on facts, and there is absolutely no cause of action on the part of the petitioner for filing this writ petition. Then he quotes, my lord, what is the, from where it is not, my lord, known. It is well settled salutary principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and in no other manner. Now, my lord, regarding this submission, I'd like to deal with this first, my lord. Firstly, your lordship will see the first quotation at paragraph 5. The state level scrutiny committee shall be the appellate authority in respect of any recommendation of the district scrutiny committee, and the state government in the concerned administrative department shall be the appellate authority. My lord, the director has not placed on record, my lord, any recommendation or, my lord, absence of it. Unless that is there, my lord, the question of filing an appeal does not arise. Even otherwise, my lord, your lordship is aware of the legal principle that, my lord, when fundamental right of a person is violated, my lord, alternative remedy is no bar.
for entertaining the rate petition. For that, my lord, if your lordship directs, my lord, I can produce the case laws. There are, my lord, several case laws on this point. Because, my lord, if there is an alternative remedy, assuming, my lord, the alternative remedy is there. In my case, my lord, they have not shown anything to show that, my lord, there was recommendation or that recommendation, why it has been rejected. That is also, my lord, not placed on record. Even if assuming, my lord, that is there, then, my lord, these are the decisions. May I give the citation, my lord? If required. There are many decisions on this, my lord. How the court has to deal when there is an alternative remedy. 2021, volume 6 SCC, page 15, UP Power Transmission Corporation, paragraphs 67 and 68. Then, my lord, another case, these are our latest cases on this point. 2021, volume 16, SCC, page 35, Unitech Limited. Relevant paragraphs will be Unitech Limited, paragraph 39.4, 39.4. There, my lord, the principles have been laid down. 39.5 and 39.6. Then another decision of 2021. My lord, there are many decisions. I think these two decisions will be enough, my lord. Because the court has to see, my lord.
You've got a copy?
My lord, I'll just paste it, my lord. I'm sorry, my lord, I did not get a copy right now. I'll just paste it after some time and get a printout. Because of the, my lord, electricity, we could not get the printouts in the morning. Then, my lords, the on merit, the stand of the director is at paragraph 6 and 7. May I read that, man?
Yes.
That the deponent begs to state that the college authority of Jamunamukh College, Jamunamukh, Nagaon at venture stage had appointed Muhammad Rafiqul Islam, the petitioner, as assistant librarian by the order number such and such dated 3/12/2010. Accordingly, Mr. Islam had joined in the college as assistant librarian on 10/12/2010. The Jamunamukh College Authority had upgraded Muhammad Islam from assistant librarian by the order number such and such dated 28/6/2012 and continue his service as librarian as stated in the individual information submitted by Mr. Islam, countersigned by the principal Jamunamukh College dated 6/12/2019. Para 7, that the deponent begs to state that the Assam Education Provincialization of Services of Non-Teaching Staff of Venture Educational Institution Act 2018 at section 4, bracket 2, Roman 2 and 3 clearly mentioned that the employee to be provincialized under this act must have minimum educational and professional qualification as laid down under the relevant service rules as on 1/1/2011 and must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution, which must be 31/12/2010 or prior to that date. Now, my lord, I'll go back to the date your lordship has already noted down. The petitioner joined his service on 10/12/2010 and requirement of 6 years is, my lord, as on 1/1/2017. So he has served, my lord, more than 6 years. I'll draw your lordships to the section, my lord, that is the requirement and that he fulfills. Now, paragraph 9, then thereafter, my lord, before 31, neither he has rendered his service as assistant librarian for counting of 6 years continuous service as on 1/1/2017. This is, my lord, factually wrong. That the deponent begs to state, paragraph 9, that the petitioner acquired Bachelor of Library Science on 12/9/2010, Master of Library Science on 26/10/2011, and acquired PhD in 2016 from Carlock's Teachers University, a state private university of Gujarat. The petitioner, being a regular student of private university outside Assam, showed continuous service of 6 years and 22 days as librarian at Jomunamuk College in self-declared individual format for provincialization. Now, my lord, they want to delete this period of my lord PhD from the my lord total period of service that I have counted. Now, my lord, I have made a statement, my lord, for doing the PhD. I have taken the my lord study leave, and your lordship is aware, my lord, when one is in a study leave, my lord, he's my lord, the teaching experience does not go. My lord, his experience in service, my lord, cannot be said to be, my lord, not there. So this is the stand of the my lord authorities. Now, regarding the amendment, paragraph 11, my lord, they have said that the deponent begs to state that the Assam Education Provincial Service Act 2018 has amended by the government of Assam in 2020 with amendment of schedule under section 2D4 and 6.1 for upgradation of an employee, that is tutor librarian, getting fixed monthly salary on provincialization to get his pay and allowances as librarian as per UGC guidelines in force. In the said amended schedule, the date of issue of his appointment order means the date of issue of provincialization order under section 4.1 of the Act and not the initial date of appointment at venture stage. My lord, when a college is provincialized, the period of service has to be, my lord, during the venture stage. And my lord, this I fail to understand, my lord, what they want to say. In the same,
Let us read it again.
my lord. Paragraph 11, I read again, my lord. The deponent begs to state that the Assam Education Act 2018 has been amended by the government of Assam in 2020 with amendment of schedule under section 2D 4.1 and 6.1 for upgradation of an employee, that is tutor librarian, getting fixed monthly salary on provincialization to get his pay and allowances as librarian as per UGC guidelines in force. In the said amended schedule, the date of issue of his appointment order means the date of issue of provincialization order under section 4.1 of the Act and not the initial date of appointment at venture stage. This means that, my lord, after the provincialization, that will be taken as a date of appointment, and thereafter, my lord, after 6 years, you'll get the benefit. My lord, the experience, while the consideration for provincialization has to be, my lord, at the venture stage. That, my lord, they are denying. And most importantly, my lord, in paragraph 29 of my writ petition, I have made an averment paragraph 29 at page 18, that the petitioner begs to state that thereafter, in pursuance of the said amendment, service of one similarly situated person, namely Manjula Deka of Chotia College, Sutia, in the district of Biswanath, has been provincialized as a librarian of the said college by order dated 11/2/2021 with effect from 1/1/2021. And that order, your lordship will get at page 68. This is the order dated 11th February in exercise of the authority conferred under provision 4.1 of the Act 2018 as and Amendment Act 2020 in pursuance of the government sanction order number such and such. The service of the following employee of Sotia College has been provincialized, and she now employee of the state government with effect from 1/1/2021 with the following terms. Your lordship will find Manjula Deka, name of the post, tutor librarian, date of joining, this has been given. Now, your lordship will kindly take note of the fact that the affidavit in opposition has not been, my lord, replied to paragraph wise. They have taken these two grounds primarily, my lord. One is the alternative remedy of appeal, and the other is that, my lord, that you have to be provincialized first, thereafter have the experience, and then only, my lord, you will be. Now the question is, my lord, how can I be provincialized without giving any benefit? Now, in this affidavit, your lordship will find they have not given Parava's reply. Paragraph 4, it states, my lord, that the deponent begs to state that instead of giving Parava's reply to the writ petition, it deems it appropriate to place the relevant material facts for proper adjudication. Now, my allegation that a similarly situated person has been given, at least one, my lord, has been given, that has not been controverted, my lord. This is violation of Article 14, very clear violation. They have not controverted. They do not say that, no, her case is different and she was provincialized, your case is different. That is also not there. Therefore, my submission before your lordship, my lord, your lordship has seen the, my lord, Amendment Act 2020 at page 66. From there, my lord, it is very clear. Then I am entitled to get the page 66, my lord. This is the 2020 amendment. And by virtue of this, my lord's note and the proviso, I am entitled to be provincialized. My fundamental right has been violated, therefore there is no question of filing an appeal. An appeal can also not be preferred because of the fact that you have not placed on record any material that, my lord, my case has been rejected by the scrutiny committee, and whether, my lord, it contained any reason. And thirdly, my lord, there is violation of Article 14. Therefore, my prayer before lordship that, my lord, direction be issued to consider provincialism of my service in terms of the 2020 amendment. I may give a reply, my lord, after my learned friend makes his submission.
May it please your lordship. The lordship may kindly come to the pair portion, lordship. What is the pair of the petitioner first, lordship? It's in page 23, lordship.
Yes.
First pair is, lordship, a writ of or in the nature of mandamus or any other appropriate writ, order or direction should not be issued, directing and commanding the respondent to consider the case of the petitioner for provincialization of his service, who has been serving as a librarian in the Jamunamukh College, Jamunamukh Huzai, in terms of the provisions of Act 2018 and the Amendment Act of 2020. So, lordship may kindly mark the last 3 lines, lordship. Provincialize his service, who have been serving as a librarian in the Jamunamukh College, Huzai, in terms of the provision of 2018 Act, lordship. His basic parish, lordship, his service should be provincialized, lordship, as per the 2018 Act, as a librarian in the Jamunamukh College, lordship. Next, lordship, a writ of or in the nature of mandamus or any other appropriate writ, order or direction should not be issued directing the respondent authorities to provincialize the service of the petitioner as a librarian of the state college with effect from, with all the benefits from 1/1/2021. So, lordship, his prayer is for consideration of his case for provincialization under the 2018 Act. So, lordship, we have to go by the 2018 Act, the provisions, lordship. Then, lordship, now my lord may directly come to our affidavit, lordship. Our affidavit, which we have stated, lordship. Regarding alternative remedy part, I will address last, lordship. First, I will address regarding some, lordship, requirement. Who should be considered for provincialization after 2018 Act and what condition he should fulfill, lordship. So, my lord may kindly come to paragraph 6, lordship. The deponent begs to state that the College Authority of Jamunamukh College, Jamunamukh, Nagaon at Venture Stage had appointed Muhammad Rafiqul Islam as Assistant Librarian by Order Nong so-and-so on dated 3/12/2010, lordship. And accordingly, Muhammad Rafiqul Islam joined the college as the Assistant Librarian on 10/12/2010. My lord may kindly mark it. His appointment was as an Assistant Librarian on 3/12/2010, lordship, and he has joined the service on Assistant Librarian on 10/12/2010, lordship. Then, lordship, The Jamunamuk College Authority had upgraded Muhammad Rafiqul Islam from the assistant librarian by order dated 28/6/2012 and continue his service as librarian as stated in the individual information submitted by the Muhammad Rafiqul Islam, countersigned by the principal of Jamunamuk College dated 6/12/2019. So then my lord may kindly mark the date. This date is very important, Lordship. On 28/6/2012, Lordship, the petitioner was upgraded as a librarian, Lordship, of Jamunamuk College, and petitioner seeking provincialization in the post of librarian, Lordship. My lord may kindly mark it. He is seeking provincialization in the post of librarian, and he was appointed or upgraded to the post of librarian on 28/6/2012, Lordship. So Lordship may kindly mark it. This date is very relevant. As because for consideration of his case, Lordship, the period should be counted from 28/6/2012 when he was appointed as a librarian, Lordship. He is seeking the post of librarian, not as assistant librarian, Lordship. If he is seeking the provincialization for the post of assistant librarian, then his service period should be considered from 3/12/2010. If he continued that position, then till today also that period is considered. But if there is a break in service or another upgraded post, then his period should be considered from up to that period when he was in that particular debt post. That is, in respect of Lordship, assistant librarian, he was continuing service 3/12/2010 to 28/6/2012, Lordship. And as a librarian, Lordship, he is from 28/6/2012, Lordship. So this date is very important, Lordship, for consider his case, Lordship. Now, my lord may kindly come to paragraph 7, Lordship. Paragraph 7 says that, Lordship, that the deponent begs to state that the Assam Education Provincialization of Service of Non-Teaching Staffs and Venture Education Institute 2018 at section 4(2), Roman 2 and Roman 3 clearly mentioned that the employee to be provincialized under this act must have a minimum educational and professional qualification as laid down under relevant service rule as on 1/1/2011 and must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture education institution, which must be on 31/12/2010. Then my lord may kindly come to the our statute books, Lordship, 4(2). That book, Lordship. Page number 93, Lordship.
Yes.
93, Lordship, 4(2), Roman 2. Roman 2 says that, Lordship, regarding qualification part, he should attain, Lordship, before 1/1/2011, must have minimum educational and professional qualification as laid down under relevant service rules as on 1/1/2011. Then 3 is very important, Lordship. Must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture education institution, which must be on 31/12/2010 prior to the date, Lordship. So
Must have rendered at least
6 years service. 6 years continuous service, Lordship. 6 years continuous service, he should render to a particular post, Lordship. If he is seeking as a assistant professor, Lordship, he should be, Lordship, continuous in the party for the post of assistant professor for 6 years for Lordship prior to 1/1/2017. If he is seeking regulation in the librarian, he should completed the 6 years service as a librarian, Lordship, prior to 1/1/2017. If he seeks in the post of assistant librarian, he should complete the 6 years period, Lordship, up to 1/1/2017, Lordship. If the particular concerned person has fulfilled the required minimum qualification, which is the entry point, that is the 6 years, that he is come within the considered zone, Lordship. I will explain, my lord, Lordship.
just 5 minutes.
So, my lord, 4(2) Roman 3, Lordship, it says that must have rendered at least 6 years continuous service on 1/1/2017 from the date of joining in the concerned venture education institution, which must be on so. So, Lordship, for particular post, Lordship, one candidate seeking regulation or provincialization, not regulation, provincialization, Lordship, he should be completed continuous 6 years service in that particular post, Lordship, prior to 1/1/2017. So, my Lord, may kindly come to
No,
please.
here it does not say post. It says continuous 6 years.
Continuous 6 years, Lordship, continuous 6 years for which we have to consider, Lordship. If one person continuously working in the grade 4, Lordship, he is seeking, Lordship, after attending the qualification, the librarian, Lordship, whether he should be treated as a qualified
Here
person,
it says
Lordship.
must have been to 6 years continuous service.
6
Continuous
years,
service.
6 years continuous service, it implies that, Lordship, the person should be continuously service in that particular post, Lordship. If he is not completed, he is not a required qualification, Lordship, for a particular post, Lordship, whether he can be, Lordship, treated as a Lordship qualified person in that particular post, Lordship. So, Lordship, may kindly peruse the resolution, Lordship. It will be very clear, Lordship, the query put by the Lordship.
Which resolution?
Resolution of the Lordship, page 46, Lordship. Page 46 of the repetition. Vernacular portion is, Lordship, in page 48. Lordship, in the translate portion is page 46. Lordship, in last 5th line, further as per the GB's, Lordship, got it?
Yes.
Further, as per the GB's resolution number 2, dated 1/12/2010, presently serving assistant librarian Mohammad Rafiqul Islam is upgraded to the post of librarian with effect from date of his joining in the college as he acquired the academic and professional qualification, Lordship.
So this also says
Lordship.
upgraded to post of librarian with
Post
effect,
of librarian, Lordship.
with
Post of
effect-
when
no.
he
with effect from the date of his joining.
joining, that is, Lordship, that post, Lordship. It is on, Lordship, page 28/6/2000, page 49, Lordship. Page 49. Page 49, Lordship. Now the GB has decided to upgrade him from assistant librarian and regularize his service with effect from date of his joining on the duty by GB resolution dated 17/6/2012, Lordship.
No, this translation of the resolution, page 46.
Yeah. Lordship.
Is it the proper translation? Do you have any objections to this translation?
Lordship, translation of vernacular part says that, Lordship, লগতে আজিৰ সভায় 1 ডিচেম্বৰ 2010 2 নং প্ৰস্তাৱ মৰ্মে সহগ্ৰন্থাগাৰিক পদত নিযুক্তিপ্ৰাপ্ত মহম্মদ ৰফিকুল ইছলাম প্ৰয়োজনীয় অৰ্হতা সম্পন্ন কৰাত আবেদনৰ ভিত্তিত গ্ৰন্থাগাৰী পদত পদোন্নতি দি কৰ্মত যোগদান দিনৰ পৰা কাৰ্যকৰী হোৱাকৈ নিয়মীয়া কৰে। That particular post, Lordship.
No, here it says from the date of his joining in the college.
From the date of joining in the college, Lordship, it is not there in the vernacular portion, Lordship. It is says that গ্ৰন্থাগাৰিক পদত পদোন্নতি দি কৰ্মত যোগদানৰ দিনৰ পৰা কাৰ্যকৰী হোৱাকৈ নিয়মীয়া কৰা হ'ল। It says that he was upgraded to the post of librarian and he was regularized from the date of joining. It's not says that from the date of initial joining, Lordship.
It does not say from the joining in the college.
No, Lordship. No, Lordship.
I don't know.
No, Lordship, it is there, Lordship. Then, Lordship, other person can also verify, even college, my brother is from the college, he can also say that vernacular person. Nothing is there, Lordship. Even, Lordship, suppose the date of joining is the college is also there. That also not do as per the act, Lordship. He should be particular post. That was also decided by the Honorable Single Bench, Lordship. I will place that judgment, Lordship. Regarding cut-off date, Lordship, in which post he should be there, Lordship. Vernacular portion, not a single word there, Lordship, regarding from the date of joining in the college, Lordship. Petitioner can clarify it, Lordship, if I am wrong, Lordship.
One more thing,
Lordship.
petitioner is making an allegation that similarly situated.
Answer is very simple. So, Lordship, my Lord, may kindly peruse page 68, Lordship.
Ah.
Answer is there, Lordship. Date of joining, my lord may kindly mark it. 7/11/2009, lordship. 7/11/2009. She is completed, lordship, 7 years. Yes, because she has not the qualified qualification, so she has her service was provincial as a tutor librarian, lordship. Otherwise, the date is within the lordship considered June, lordship. Here, date of joining is a librarian is lordship 2012, lordship. This is the answer, lordship. 28/6/2012. Page 49, lordship. Page 49. Annexure 13, lordship. Annexure 13, page 49, lordship. 28/6/2012. Petitioner was upgraded from the post of assistant librarian to librarian, lordship. (28/6/2012). Here, in page 68, date of joining is, lordship, 7/11/2009, lordship. So, lordship, the annexure 22, page 68, the concerned person is, lordship, cannot or should not be equated with the lordship petitioner. There is a vast difference. Regarding date of joining, as per the statute, she is under the considered zone. She is already entered in the position, lordship. Here, lordship, as per the date of joining, petitioner is not under the considered zone, lordship. This is the difference, lordship. That's why this annexure, lordship.
No, according to you,
Lordship.
petitioner joined as assistant librarian
Lordship.
on 10/12/2010.
Lordship.
Correct.
Lordship. There is no dispute, lordship.
So, counting 6 years
Lordship.
for his provincialization, he can be done as an assistant librarian.
Assistant librarian, lordship.
Yes.
Assistant librarian from 2010 up to the period, lordship, when he was, even today he is also assistant librarian, then no issue. As because my lord may kindly peruse the page 97 of the book, lordship, statute book. Page 97.
Yes.
There is a schedule, lordship. Number 1 is assistant librarian. My lord may kindly peruse. Assistant librarian. If his claim is there is a post of assistant librarian, lordship, it is the duty of the authority to, lordship, consider his date of joining from the date when he was joined as assistant librarian, lordship, or appointed as assistant librarian, lordship. There is no dispute, lordship. We cannot, lordship.
Here there's no librarian post.
Librarian by way of amendment, lordship, that is there.
Okay, yeah, that
By way of amendment, lordship. As for example, lordship, library assistant, lordship. Say my lord made that schedule, lordship. Library assistant, lordship. The one person was appointed as library assistant, lordship. After acquired the qualification, lordship, he can be, lordship, to the assistant librarian also, lordship. Promotional post, lordship. Say for example, lordship. But that assistant librarian post or seniority should be counted from the date when he was appointed as the assistant librarian, lordship. Not from the date as a library assistant, he should be treated as assistant librarian. There is 3 posts is there in the university level, lordship. Assistant librarian is there, deputy librarian is there, librarian is there, lordship. There is a 3 posts of library in the department of library, and lordship, library assistant is a gate 4 post, 4 person is there. In the college, in level of college level, lordship, there is a 2 posts, assistant librarian and librarian, lordship. There is no dispute, lordship. If his claim is in the assistant librarian, it is from the date of that. And if his claim for the post of law, lordship, librarian, from the date when he was joined as a librarian, lordship. This is the issue, lordship. And regarding that, lordship, page 68, lordship. Page 68, lordship, totally different footing. She was a librarian and she was appointed in, lordship, 7/11/2009. As because lordship, she has the not required qualification, there is a provisions for tutor librarian as a who are not required qualification. They are also lordship for the assistant, tutor assistant professors also lordship. So her service was appointed as a tutor librarian lordship after the 2017 Act lordship. In the 2011 Act, there is no provisions regarding lordship tutor part. 2011 Act says that he or she should be the required qualification, then he or she should be the considered for a particular post. But 2017 Act and 2011 Act, 18 Act, there is a provision if concerned person is otherwise in the considered zone and she has not the required qualification, say net slate lordship, then she should be lordship provincialized as a tutor lordship. And within a 5 years period, he or she should be complete the lordship required qualification. Till then, he or she should be as a tutor lordship. Here also lordship, that's why page 68 lordship. She has not the required qualification, so she was appointed as a tutor librarian on the basis of the joining date 7/11/2009 lordship. The petitioner's case and page 68 is a totally different footing lordship. It is not a equal footing. Now lordship,
You could have at least answered that in the affidavit.
lordship, it is there lordship. As per the records lordship, record itself says that. It is not our document lordship. I am arguing on the basis of their document lordship. Their appointment letter is there. That particular persons whose appointment letter is annexed here with this document is there lordship. It was not annexed by me lordship. Just I have pointed out lordship why she or he should be, he was provincialized. As because he or she in the considered zone as per section 4(2) Roman 3. As because he is within the considered zone, so her service was provincialized. As because she has no required qualification, that's why her service was provincialized as a tutor librarian. And regarding lordship, that amendment part lordship. Itu relation itu, point to relation itu. Then lordship, page 66. Page 66 of the repetition. Regarding salary part, that amendment part lordship. And it was lordship, we have explained in paragraph 11 of our affidavit. My lord may kindly mark it. If lordship permit, I can read paragraph 11 simultaneously with lordship that.
Yes.
Lordship. The deponent begs to state that Assam Education Provincialization of Service of Non-Teaching Staffs of Bensa Education Institution Act 2018 has been amended by the Government of Assam in 2020 with amendment of the schedule under 2D41 and 61 of the upgradation of an employee, tutor librarian getting fixed monthly salary on provincialization to get his pay and allowances as librarian as per UGC guideline in force. In the said amendment, schedule date of issue of his appointment order means the date of the issue of the provincialization order under section 4(1) of the Assam Education Provincialization of Service Non-Teaching Staffs Bensa Education Institution Act 2018, not the initial date of appointment of the Bensa State lordship. Here lordship, the persons who are considered zone in the Bensa state who has fulfilled the required qualifications or who has fulfilled the criteria prescribed in section 4(2) Roman 3, that is 6 years period, her or his service was provincialized, and from that day, his or her service was taken as a government employee lordship, and that's why lordship kindly peruse page 66 lordship, page 66 of the writ petition lordship. Any librarian who has already acquired the qualification required as per the UGC norms in guideline in force on the date of issue of his or her appointment order shall be entitled to pay and allowances equivalent to assistant professor from the date of issue of his her appointment order. There is a salary part, Lordship. If a person, if a librarian who has acquired the UGC's prescribed qualifications and whose service was provincialized, Lordship, then Lordship, he or she should get the UGC's required pay scale, Lordship, from the date of appointment order, Lordship. That means, Lordship, when his service was provincialized, Lordship. Otherwise, salary part is, Lordship, there is no issue regarding Bensa state government is giving the salary loss. They are purely in the Bensa state, Lordship. There is no question of the salary loss from the government side. So, Lordship, on the date of issue of his or appointment order, shall be entitled to pay and allowances equivalent to assistant professor from the date of issue of the appointment letter. My Lord, may kindly mark it. The language of the statute itself, Lordship, clearly stated that, Lordship, there is no ambiguity, Lordship. There is no need of any interpretation, Lordship. Then, Lordship, provided that librarian who acquires such qualification within 5 years from the date of issue of his appointment order shall also be entitled to pay and allowances of equivalent to the assistant professor with effect from the date of acquiring such qualification as UGC norms and guidelines for the time being enforced. That part relates to, Lordship, page 68. The persons whose service was provincialized as a tutor, Lordship, that persons will be covered by that second portion, Lordship. Provided that in the tutor there is a provision, Lordship, he or she should complete within a period of 5 years the required qualification. If the persons complete the required qualification within that period, Lordship, then she will get or he will get the UGC scale of pay at par with the assistant professor from the date of acquired qualification, Lordship. The language of the statute is very specific, Lordship. Very clear, Lordship. It not says that this one or that one will get. It says that the persons who acquired the qualification within the prescribed 5 years period from the date of regulation or provincialization, he will get the UGC scale of pay at par with the assistant professor from the date of acquiring the qualification. And this amendment portion, Lordship, nowhere related to the case of the petitioner. If he is within the ambit of the Lordship 2018 Act, if his service was provincialized as a librarian, Lordship, then if he acquired all the required qualification, then he will get the, Lordship, required UGC's benefit at par with the assistant professor from the date of the appointment order, Lordship. Here, petitioner service was not provincialized, Lordship, under the 2018 Act, Lordship. So his case is not covered by the first para of the note, Lordship. And proviso part also, Lordship. If his service was provincialized as a tutor librarian, Lordship, then proviso part will come. When he acquired the required qualification, then he will get the UGC's scale of pay at par with the assistant professor from the date of acquiring the qualification. Here, in the note 1 also, in proviso part also, Lordship, is not related to the petitioner's case. As because his service was neither provincialized as a librarian nor provincialized as a tutor librarian. And, Lordship, regarding, Lordship, alternative remedy part, Lordship.
1 minute.
Lordship.
Yes.
Then if Lordship take the book, then also Lordship may kindly peruse section 7 Lordship. Page 94 Lordship. Sections 7 Lordship.
Yeah.
Section 7 says that Lordship, district scrutiny committee or state level scrutiny committee Lordship. Number one, district scrutiny committee Lordship. The district scrutiny committee and state level scrutiny committee as constituted under section 13 of Assam Provincialization Act 2017 Lordship. In each district and at the state level shall scrutinize the service records and other related issues of the non-teaching staff of the venture education institution for the purpose of provincialization of the service under this act. The list of non-teaching staff of those whose service are provincialized under this act shall be finalized by the manner prescribed under the aforesaid act. So, Lordship, the person concerned should be provincialized, Lordship. At first, his case should be placed before the Lordship, district level scrutiny committee. There is not a single aberration, Lordship, regarding whether his case was placed before the district level scrutiny committee or not, Lordship. Whether there is a recommendation from the district level scrutiny committees or not, there is not a single aberration. Whether his case was rejected by the district level scrutiny committee or not, that was not a single aberration. Even the particular college, which is the duty to forward the list to the district scrutiny committee, they have also not come up with a Lordship any pleadings that his case was placed before the district level scrutiny committee. His case was considered by the district level scrutiny committee, or his case was rejected by the district level scrutiny committee. Nothing is there, Lordship. Not a single aberration, nothing is there, Lordship. It is not our duty to look after it, Lordship.
Who is the appellate, who is the provision?
Appellate authorities 8 Lordship. The state level committees shall be the appellate authority in respect of any recommendation of the district level scrutiny committee or state level government is the concerned administrative department. Shall the appellate authority in respect of the recommendation of the state level committee, Lordship. If Lordship, district level scrutiny committee, Lordship, rejected the case of the petitioner, then he can prefer a appeal, Lordship, before the state level committee, Lordship. If state level committee, Lordship, rejected the case of the petitioner, then it is the appropriate government, that is the Department of Higher Education. It is the procedure prescribed by the state laws. Here, nothing is there, not a single document is there, not a single aberration is there. Whether his case was placed before the district level scrutiny committee or not, whether his case was considered by the committee or not, nothing is there. Not a single aberration is there. So, Lordship, we have to act as per the procedure prescribed or as per the prescription prescribed by the state Lordship. Nothing beyond that. The golden principles of law, Lordship, which was formulated in the Privy Council in Nazir Ahmed case, Lordship, it was reiterated in 2023, also in the Mohan Singh case, Lordship. We bound by the Lordship state laws.
See, the issue is this.
Lordship.
The district scrutiny committee did not even consider the case of the petitioner.
This is not there, Lordship.
No, he doesn't say that, my lord. In their affidavit, he doesn't say. Where, my lord? Oh, let him complete, my lord. I'll make my reply.
It is not
Let
there.
him complete.
It is the duty of the, he has preferred a petition. Petitioner has preferred a petition before the court with a prayer to provincialize his service, Lordship. It is the duty of the petitioner to, Lordship, disclose all the facts, Lordship. It is not the department, Lordship. It is the duty of the petitioner to disclose the facts, whether his case was placed before the district level committee or not. It is not our duty. We are not disclosing. It is the duty of the petitioner, Lordship. If he says that his case was placed before the district level committee, his case was rejected, Lordship, then, Lordship, he should go to the appellate provision, Lordship. This is not there, Lordship. Not a single aberration is there, Lordship. Only by, Lordship, filing a petition with a prayer for regulation, with a prayer for provincialization, Lordship, that will not do, Lordship. Whether everything is go within the parameters of the law, that should be considered, Lordship. Nothing is there, Lordship. Even, Lordship, his case is, for a moment, his case is, Lordship, accepted. District level commission accepted. Whether it was accepted by the state level committee or not. When district level committee was forwarded to the state level committee, nothing is there, Lordship. It is the duty of the college to place it, Lordship. Not our duty, Lordship. It is not our duty, Lordship. It is the duty of the college to place all the materials and relevant facts, relevant documents before the district level committee, whose case should be considered for provincialization. Nothing is there, not a single document is there, Lordship. Otherwise, regarding statutory prescriptions, we are bound by it, Lordship. We are bound by it. We cannot deviate it, Lordship. As per the golden principle of law prescribed by the Privy Council, reiterated again and again by the Honorable Supreme Court in 2015 Ceremony case and again 2023 Mohan Singh case, Lordship. We are bound by the dictum given by the Honorable Apex Court. And just I point out, Lordship, two judgment I am, Lordship, given regarding alternative remedy. I will not read it, Lordship. It is, Lordship, State of Maharashtra and others versus Great Ships India Limited. And it's from paragraph, Lordship, 6 onwards. Just I can read it. 2022 AR SC Civil 2707. 22 AR SC 4408.
Come again.
Lordship, I just forward the copy, Lordship. And paragraph 6 onwards, Lordship.
2022 AIRSC 4408.
Regarding
1 minute.
Monu SC 0919 2023.
Para 6.
There are 6 onwards, Lordship. All the previous judgment and dictum of the Honorable Apex Court was, Lordship, beautifully, Lordship, discussed here. After that, the findings is there, Lordship. Paragraph 6 onwards, Lordship, that I have already marked it, Lordship. Paragraph 6, not Lordship, this, that, another, from this, other side. Paragraph 6 onwards, Lordship. Paragraph 6 onwards. All the earlier dictum was, Lordship, discussed here, Lordship.
Yes.
Regarding, Lordship, statutory prescriptions, Lordship, I am relying, Lordship, the latest judgment of the Honorable Apex Court, Lordship, where the Honorable Apex Court discussed the golden principles of law in a Nazir Ahmed case, Lordship, as well as Chandrakishore Judge case, Lordship, as well as Shirukari Monish case, Lordship, and Lordship, the Municipal Corporation of Greater Mumbai case also discussed, and ultimately says that, Lordship, where the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner, following the provisions of law, without deviating from the prescribed procedure, Lordship. Here I am relying, Lordship, paragraph 14 onwards, Lordship. Paragraph 14 onwards, Lordship.
What is the citation?
Citation is the Monu, Lordship, Monu there.
Oh, Manu.
Monu, Lordship. This also, Lordship, in AIR also there, Lordship. I am not bringing the copy, AIR copy, Lordship. Motion AIR copy.
Para?
Paragraph 14 onwards, Lordship. 14 onwards, Lordship, up to the Lordship.
Yes.
So, Lordship, I am concluding just 3 lines, Lordship. Here, Lordship, page 68, the persons who petitioner states there is a similar situated. He is not a similar situated person. As per a date of joining, Lordship, in 1997, Lordship, 2009, Lordship, date of joining, and may admittedly petitioner joining to the post of Lordship, Assistant Librarian's Lordship, Librarian's Lordship, 28/6/2012, Lordship. 28/6/2012, he joined as a librarian, Lordship. So his case or her case is not in the similar footing, Lordship. As per the joining, Lordship, the petitioner not fulfill the statutory prescription prescribed under section 4(2)(3) of the 2018 Act. He should be in a particular post, Lordship, for a period of 6 years, Lordship. As because there is a schedule of post, Lordship. Schedule is there, Lordship. Post of assistant librarian is there. Librarian is there, Lordship. So, Lordship, if he is date of joining from the date of librarian, it should be counted from the 6 years period, not in other posts, Lordship. So, Lordship, his case is not covered under section 4(2)(3). That's why he is not in the considered zone, Lordship. Otherwise, also, Lordship, not a single document, not a single environment is there. Whether his case was placed before the district level scrutiny committee.
Let us read that 4(2)(3).
4(2)(3), Lordship.
It's quite clear.
Let me reply, my lord. Let him complain, my lord, I'll reply.
Yeah, no, let us read once.
Must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture education institution, which must be as on him prior to date. Regarding date of joining, he should be that particular post, Lordship. If he is, Lordship, seeking a regulation for the post of librarian, Lordship,
It says from the date of joining in the concerned venture educational
concerned
institution.
venture educational institution subject to, Lordship, that post, Lordship, not as a whole, Lordship. He may join in the, Lordship, the grade 4 post also, Lordship, beyond post also, Lordship. Whether in the meantime he acquired a qualification, he was upgraded to a particular post, whether grade 4 period should be treated lost in the particular post qualification, that cannot be lost. That cannot be lost. So, Lordship, he has not qualified 6 years service in the post of librarian, Lordship. That's why, Lordship, his service is not considered. Suppose, Lordship, today we have accepted he has completed 6 years service in the post of librarian. Then also this petition is not maintainable. There is not a single environment, whether his case was, Lordship, rejected or accepted by the district level committee. Nothing is there. If his case is accepted, it was gone to the SLC, Lordship. And if SLC rejected, it was to the government, Lordship. Nothing is there, Lordship. The writ petition is, Lordship, not maintainable at this present form, Lordship. First of all, Lordship, he is not a single document, nothing is there regarding, Lordship, the procedure prescribed by the section 7 fulfillment. Nothing is there. And 4(2)(3) is not, Lordship, completed. And, Lordship, amendment part, amendment of page 66, it says that in respect of the persons whose service was appointed, Lordship.
That I'm clear. That I'm clear.
What is my submission, Lordship?
I'll just hear the college. You're appearing for the college?
My lord, I have got strong objections to his submission, my lord.
No, I'll let you reply.
My lord.
Let me just hear the college.
My lord, this gown does not give a license to say anything that comes to the mouth.
And petitioner also not give a license to anything say before.
Wait, I am replying. I did not disturb you when you spoke.
I didn't study.
I am not saying that.
Mr. Chowdhury,
I am not
one
saying that.
minute.
Why you
my
are
lord,
taking my ground
He
lawsuit?
makes very
Why
serious
you are taking my
allegation
ground lawsuit?
regarding translation.
Why you are
My
taking
lord,
the
I
ground?
dare him. I
Ground.
dare him to prove that, my lord, there was anything wrong in the, my lord, translation. My lord, we have got official translators here. Let them go. We have given the, my lord, original vernacular and the translation, and he makes a serious allegation that, my lord, the translation is not correct. He should be reprimanded, my lord, after your lordship finalizes it from the, my lord, official translator of this high court, my lord.
Okay.
This, and this is not in the affidavit.
1 minute, Chowdhury.
This
Yes,
is my
Anything he
submission
cannot, my lord,
and again
submit.
and again
Mr.
retracted
Gogoi,
lordship.
Gogoi,
This is
1
my
minute.
submission lordship.
Abidin,
If lordship the respondent says against the petitioner, then
Gogoi,
always they will do lordship.
please sit down. And I have just one question to ask you. Was the case of the petitioner placed before the district scrutiny committee?
My lord, yes, it is there because I being the secretary come the principal.
Have you placed it?
Yes, I play, and that is there in paragraph what my friend says. Possibly he did not go through paragraph 25. Paragraph 25, the writ petition, it is clearly there that the principal submitted all the information, including the individual format of the petitioner before the district scrutiny committee.
So was it considered by the district scrutiny?
That is not known, my lord. All of a sudden that in the 5th February 2021, all the other non-teaching staffs were only it is left
Let
out.
us see para 25.
Para 25. My lord, para 25, page 16.
Yes.
My lord, as your lordship understands the and even understands our situation for whom we are representing. It is the total fight between the petitioner and his right claimed from the authority who are responsible to give him the appointment. I have been made a party only in order to show that certain things possibly petitioner has made and certain documents annexed which are given by me, so that at least I could address this court saying, yes, these documents are correct, it is given by my office. That is the only part from my side. I, as an individual and the secretary of the institution, what the petitioner has stated, it is correct as far as his date of joining, his upgradation, and now he is claiming the benefit of librarian. First of all, my lord, we should keep one thing in our mind. 2011 Act earlier, which was there for provincialization, after the 2016, when it was said ultra vires, then 2017 Act came for the teaching, and 2018 came for the non-teaching as far as the college is concerned. But overall, if we understand, it is a beneficial legislation in order to give certain benefit to the people who are serving for a long time. They did not have any right. They did not have any fundamental right to approach this honorable court. Serving in a venture school, they did not have any enforceable right to address this court for claiming any right of provincialization. It is the government who created this right in order to give them certain benefits who are serving. Even my lord has come across that for 20 years, 25 years, they were serving without any benefit. So ultimately, we can term it is a beneficial legislation in order to provide certain right or certain relief to these persons who are working in these institutions. And after all, imparting education to the next generation of the country. So it's not a political lecture. I would not have said anything because it is the fight between the petitioner and the state. But if my lord permits, proper adjudication of the matter, when the question of two legal principles emerged from this argument of my friend, I would like to just address on that point, man. If your lordship permits, I'll say that, otherwise.
No, I just wanted to know one thing, whether you placed the case of the petitioner before the district.
It is there.
So
Correct.
para 25 says it was placed. You also say that you have
Yes,
placed it.
yes, yes.
Okay, we'll see. Okay, Chowdhury.
Well, yes. Only one thing I would like to bring to your lordship attention. My lord, if your lordship looks at this amendment which was cited by both the sides and the note, my lord. If you remember that note.
Page 66.
Yes, my lord. Would your lordship be pleased to see once more, my lord?
Yes.
My lord, what I understand from the argument of the state, the first note is in respect after the provincialization order is effected. Is it correct, my lord? This is wrong. This placing before the court is wrong. Why I'm saying this librarian was inserted by this amendment itself. Earlier in 2018 amendment, librarian post was not there. So where is the question of appointment comes? It is by virtue of this, the appointment to the librarian were made. Have you got it, man? This note cannot be applicable in the manner it is said that it is beneficiary will be given to the person who got the appointment as a librarian. What I'm saying, through this 2020 amendment, the librarian post was inserted in the 2018 Act. Earlier it was not there. So question of appointment that is under 2018 or whatever, it is not there. It does not arise. This is the first time the librarian post has been inserted. The note is for the beneficiary of those persons who are serving in the venture institute as a librarian. And my lord, second part, provided that librarian who acquires such qualification within 5 years. My lord, got it. In this case, in this instant case, this writ petitioner acquired the benefit even prior to the act has come into the scene. He was appointed in 2010, but in 2012, exactly, my lord, 26/10/2011, he got the, if your lordship pleases to note down, my lord, MLI SC, Master of Library Science, he acquired on 26/10/2011. 26/10/2011, and he was upgraded on 28/6/2012. So the second part, provided that librarian who acquires such qualification within 5 years, that is given the benefit to the persons who have been appointed as a librarian. They have to acquire. My lord, one thing I would like to make this honorable court clear. The persons who have been appointed as a tutor librarian, they get the required qualification within 5 years. Then they get the higher scale. Over here, the note comes before this court in the year 2020. This person already acquired this higher qualification in the year 2011, and he was upgraded in 2012. What my lord has pointed out, section 4, that is 4(3). If my lord takes it 4(1)(2)(3), nothing to do with the post. Only one analogy I'll say before I close, my lord. If that is the case, in provincialization matter, no headmaster would have been provincialized as a headmaster. Because they were always appointed as a headmaster among the assistant teachers in the venture schools just 2-3 years prior to the provincialization. If this analogy is taken, what my friend says, no headmaster would have been appointed as a headmaster. That's all.
My lord, let him also say about the, my lord, translation part, because it is the college's document, my lord.
Yeah, let us have a look. Who translated this? Petitioner translated.
Yes, my translation, but the original vernacular has also been, my lord, placed on the court
Yes.
in the petition. Had there been, my lord, a case that the correction, the translation is not correct, that could have been, my lord, taken in the affidavit. Now, my lord, he cannot say, and that's why, my lord, when he says this, my lord, I dare him that you prove me wrong. Your lordship may direct the, my lord, the translator, official translator to translate it and prove that, my lord, I am wrong. Otherwise, my lord, he should be reprimanded. Such a, my lord, statement should not be made in the court. Your lordship should not, my lord, permit such statements to be made, irresponsible
That
statements.
proposal, I 100% agree. Lordship may by judicial order, Lordship, appoint our official translator to translate this particular portion and compare it with the page, Lordship. 46.
Okay.
I'm agree, totally agree, Lordship.
So what do you say,
And
Abhijit?
because
Well,
the cause of
one-
and down is there, Lordship.
Yes. Can you read?
Yes, I can. My lord, these documents which have been as a resolution as well as the page 43. It is, in one sense, it is college authority giving him the documents when he was considered for upgradation. In fact, at that point of time.
No, I'm talking about the translation.
Yes, my lord, translation. If your lordship looks, only, I'll just,
No, I can't read.
I understand.
I can't read.
No, I understand. My lord may not understand, but only two words I'm showing. Page 48.
I'm on 48.
Okay. My lord, that the first resolution last two lines. Okay. Over here, what I understand, পদত পদোন্নতি দি কর্মত যোগদান দিনৰ পৰা কাৰ্যকৰী হোৱাকৈ নিয়মীয়াকৰণ কৰে। This word কৰ্মত যোগদানৰ দিনৰ পৰা, that means from the day of his appointment. কৰ্মত যোগদান দিনৰ পৰা.
Date of joining.
From the date of joining, that means I have given him the পদোন্নতি means upgradation, but at the same time পদোন্নতি দি giving him the upgradation কর্মত যোগদান from the date of joining. কর্মত যোগদান means কর্ম means work, যোগদান means the day he joined. It did not say that way, my lord, the English translation is correct. It did not say পদোন্নতি দিনৰ পৰা. Suppose the word পদোন্নতি দিনৰ পৰা, that means day of upgradation. It did not say that. পদোন্নতি দি কৰ্মৰ দিনৰ পৰা, that means from the date of initial, from the date of work.
Okay, then we'll have it tested by the.
Yes, my lord. And see page 49. My lord, see page 49 once.
Yes. No, this I've seen. This I've seen. Here is
No.
the different thing.
No, it's the same thing. My lord, in fact, it's the same thing. Assistant librarian to librarian, my lord got it. And regularized his service with effect the date of his joining on duty.
By resolution dated
Yes, this is
76/22.
yes, this is the resolution of his upgradation,
Okay, heard.
but it is from the date of his joining. The same thing, it has to come from that resolution to over here. This order is culminated from the resolution. The wording of resolution and this are almost same, my lord.
Then I'll get it verified.
Yes.
Heard M.K. Chaudhary, Leonard, City Council. Assisted by Mr. D. Bora, Leonard Council for Education. Also heard Mr. K. Gogol, Leonard City Council, Higher Education. For the respondents, one and two, and Mr. J. Abidin, Leonard Council, 1, 2, and 1 and 3. 1 and 3. And J. Abidin, Leonard Council for the respondent. During the course of hearing, there's a dispute among the parties, particularly the petitioner and the standing council higher education, with regard to the correctness of the translation of resolution number 1 of the meeting of the governing body of Jamunamukh College held on 17/6/2012. Stop. Accordingly, the official translator of the Guwahati High Court is directed to translate resolution number 1, which is in which page is it?
My lord, page 48 is the resolution, my lord, in vernacular,
Hmm.
and
That's
our
what-
translation is at page 46.
No, your translation is there,
Yes, my lord.
but the 48
Vernacular is at page 48.
resolution number 1 of the meeting of the governing body of Jamuna College dated 17/6/2012, within bracket, page 48 of the writ petition. How long will it take? It will not, it should not take
One paragraph only, my
one
lord.
paragraph, hardly 1 hour.
Yes, ma'am. Yes. My lord, question is, my lord, whether my translation is correct or not. That has to be, my lord, ascertained.
That's why let the court, let the official translator translate this.
Yes, my lord, but let the, my lord, the translator also see our translation.
The official translator,
That part also I am indicated, lordship. At first, official translator translated, lordship. Then lordship may compare.
No, his allegation is that we have
Yeah,
wrongly translated
That's
it.
why-
One sentence can be, my lord, translated
that's
in
why
too many ways.
on top I've said, there's a dispute with regard to the
My lord.
translation. So let them translate it.
First, it's translate him, lordship. After that, lordship will take.
List the matter. We'll have to give you a date. That was- When do you want?
Any day next week, my lord.
On the hearing day you want? Okay, list the matter again on 4th of June.
My lord, only one thing, if the lordship doesn't take it otherwise, this translation or the correctness will not have any effect because it was 2012 when the act has come 2018. The provincialization mechanism is 2018.
No, there'll be some effect.
Yes, my lord, this type of irresponsible statement should not be made when, my lord, it is not taken in the affidavit.
That day you bring this books, the authorities which are cited. This-
No. You can have a responsible also.
I've given the date.
About 10 and 11, next week 10 and 11.
Yes,
Yes, 10, 11, we are taking time, my lord. Next week or after 2 weeks, it may come, my lord.
on request made by BCNL and the council for the petition. List after 2 weeks.
Any date, any day, my lord. 10 and 11, any date, my lord.
13th.
Two items, item 12 and.
Lordship, item number 12 and 14, Your Lordship. Your Lordship, the matter has been lead by Mr. Pain Chaudhary, Your Lordship, and he is engaged in a Padhat matter in court number 1. Kindly adjourn the matter for today, Your Lordship.
Okay, on request made on behalf of K. Chowdhury and senior counsel for the petitioner. List after 1 week.
Deeply obliged, Your Lordship.
To the Learner Standing Council, Dibrugarh University, to file counter affidavit.
No, instruction, two after instruction. We have already filed, my lord.
To- List after 2 weeks.
Public.
With due respect, I want to mention my lord, item number 23.
Huh.
In this case, my lord have filed the affidavit in reply, but it has not come in the record. So shortest date may kindly be.
When
fixed.
did you refile?
Yesterday, because my client has got mild heart attack. He could not come and sign it. That's why, my lord, yesterday only I could find one.
MSN Cycle and the council for the petitioner submits. That
Now he has gone to Bombay, my
That
lord.
she has filed
Treatment.
affidavit in reply. On yesterday was what?
Yesterday.
27th May. We used to verify and place the sound. List after? 1 week?
1 week, my lord. Next Thursday, my lord. Next Thursday is my lord. 13 June.
It's on 13th.
Obligement.
Looks like in item 32, I file a petition in morning. It may be called for law.
Okay.
Item 4 and 5.
Wait. This is the matter perhaps your lordship will recall, my lord. I was appointed as an LDA. And my appointment letter, your lordship will find at page number 23, my lord. Page number 23.
Yes.
And if your lordship kindly turns to the next page, page 24, clause 5. Clause 5, my lord, they say, my lord, that the engaged candidates shall have to follow the service conduct rules applicable for university employees. So there is no dispute about the fact that the Guwahati University, my lord, service rules applies in my case. And secondly, my lord, on 25/9/2021, I was arrested, my lord, in connection with vigilance PS case number, my lord, 4 of 2021. And on the very same day, my lord, I was issued the impugn termination order, which your lordship will find at page number 38, my lord. Page number 38, my lord. And your lordship will see, my lord, this second last paragraph from bottom. Page number 38.
Yes.
They say, my lord, moreover, the second paragraph from bottom, they say, moreover, the entry of the above 3 persons is restricted inside the Guwahati University campus henceforth. So this leaves room for no doubt that, my lord, this is an extremely in and out stigmatic order. They not only terminate me, they go to the extent of attaching a lifelong stigma to the effect that I cannot even enter the premises. My lord. They don't even communicate this to me, my lord. Somehow, after running from pillar to post, I procured a copy and I approached this honorable court. Your lordship had protected me, my lord. The order was stayed. They don't comply. They don't allow me to resume. I file a contempt. Contempt is, my lord, item number 5. And they don't respond to the contempt notice also, my lord. They don't file an affidavit, meaning thereby they admit that this is a willful and deliberate violation. Now, my lord, the university have filed an affidavit containing 27 pages. 27 pages, my lord. And in that affidavit, they have gone round and round, but they don't justify as to why I was not given a show cause notice, why I was not given a my lord, an inquiry why it was not held before inflicting such a stigmatic order. However, my lord, during the course of the oral arguments, now this matter has been, your lordship has been hearing this matter for quite a while. Now, during the course of the oral argument, my lord, an oral argument has been made that the inquiry has been dispensed with in my case because they thought that it was not reasonably practicable to hold an inquiry. That exception to 311(2), my lord. Your lordship won't find that plea in the entire affidavit filed by the respondent authorities, page 27. Now, this leads to the, my lord, gives rise to the inevitable, my lord, doubt that this plea, which has been taken by the authorities at this belated stage, is perhaps an afterthought. And, my lord, therefore, in fact, they have relied on Tulsiram. May I just place Tulsiram? Even I am also relying on Tulsiram, my lord. Nada. I don't want to put submission. Now, my lord, Tulsiram, there's no dispute that Tulsiram is applicable in the facts and circumstances of the present case. My learned senior friend also agrees, I also agree. If your lordship kindly turns to, my lord, paragraph 132. Paragraph 132, my lord. Page number 60 internal. Has your lordship got one? If your lordship kindly turns to the next page and second paragraph, my lord, I'm just reading out. A disciplinary authority is not expected to dispense with a disciplinary inquiry lightly or arbitrarily, or out of ulterior motives, or merely in order to avoid the holding of an inquiry, or because the department's case against the government servant is weak and must fail. So Tulsiram itself says that although there is an exception, that exception cannot be, my lord, taken lightly or arbitrarily, because you're attaching a lifelong stigma upon a person. At least you have to give him an opportunity of hearing. And if your lordship kindly turns to the next page, my lord, paragraph 137. The next page, my lord, paragraph 137. Fifth line from bottom. Fifth line from bottom, my lord. The line starting from if the reasons are. If the reasons are not communicated to the government servant, the reasons as to why they don't want to hold a disciplinary proceeding, and the matter comes to the court can direct the reasons to be produced and furnished to the government servant, and if still not produced, a presumption should be drawn that the reasons were not recorded in writing and the impugn order would then stand invalidated. So therefore, I am praying, my lord, I may be given full access to the records. On the last occasion, your lordship had directed, they had just shown me a page. I would like to go through the entire records to eliminate the possibility of any mischief. And my lord, my next limb of argument would be,
No, one thing is that if you want to go through the record.
I'll go. I may be given full access of the records, and your lordship can have it day after tomorrow, my lord.
Yes, come.
My lord,
Let him go through the records just now.
the sentence, my lord, may I repeat that sentence, my lord? Tulsiram Patel.
No, that I've seen. That I've seen. But
Your
what he
lordship
wants to,
has-
he wants to go through the records.
My lord, since my lord, the reasons for dispensing with the inquiry as per Tulsiram Patel, my lord, that may be gone through by this honorable court. No, my lord, obstacle in that, my lord, proposition of law. But, my lord, if the reasons are not communicated to the government servant and the matter comes to the court, the court can direct the reasons to be produced and furnished to the government servant, and if still not produced, a presumption should be drawn. So then I will have to, my lord, file an affidavit, my lord, in that regard, my lord.
This is the final stage. They have already filed an affidavit.
Your affidavit is already there.
Already there.
But
You have not mentioned that in your affidavit.
Not a single
has not
whisper.
been mentioned, but the inquiry has been dispensed with. That was clear in the termination order.
No, inquiry has been dispensed with. Have you mentioned that in the affidavit?
No.
My lord, inquiry has been dispensed with. It is in the termination order itself, my lord. So, my lord, I will have to go back to the entire paragraph number 134 and 135. Not a part of that paragraph number 135.
Okay,
That's
you
my
file your affidavit.
My lord.
Because, my lord, they have
And
all
the
along.
investigation is still going on.
There is already an affidavit.
One minute.
There is a vital aspect of suppression.
In the meantime, you allow him to go through the records.
Yes.
My lord,
Today itself, let me go
my
through
lord,
the records.
I have some objection, my lord.
Go ahead.
Since the investigation is still going on and the entire record, my lord, only that part, my lord, the reasons for dispense with the inquiry.
Mr. PG Fukan,
Is there for
Standing Council. Which university?
Guwahati.
Guwahati University. Is allowed how much time?
my lord,
1 week?
at least 1 week.
Allowed a week's time to file an additional affidavit in application. Yes, this on one will be what? We'll have it on 6th.
6 minutes.
Can it be, my lord, on 11th, my lord?
Your lordship is
Tuesday,
perhaps
my lord.
not there on 11th.
11th, I'm not there.
Let it be on 6, my lord.
On 6th.
And my lord, just
Let
to,
us see the affidavit. After that, I'll.
my lord, my lord. Okay. DPM.
David, my lord, regarding the reasons, my lord, for dispense with that.
Let them annex the extracts of the records.
My lord.
Obliged. Diploma.
14. Allowed to file in additional opposition indicating the reasons for dispensing with the inquiry.
Obliged. Most of.
And the last occasion, last but one, on the 3rd of May,
Hmm.
there was an order of the collateral bench in this matter, directing the SSA, Sarva Shiksha Abhiyan, to come up with all instructions. Else, the director's presence was required by this day at 2 p.m. And just 1 hour back, they have served a copy of the affidavit on us. They have served an affidavit at 1 p.m. So let it come up along with that. Probably it has not tagged with the record.
When did you file it?
Lordship, today morning you could file it, Lordship. Because of the communication, Lordship, we received it late, Lordship. But just now they have informed me that it has already been filed, Lordship.
I have been served with at 1 o'clock. So let it come up next week, my lord, on Monday.
But Mr. K.K. Mandal, the senior counsel, assisted by
A month.
A. Mandal, level counsel for the petition. Mr.
Nayak.
P. Nayak, learned standing counsel, SSA,
SSA, Lord.
submits that he has filed counter affidavit this morning. Without registry to verify.
My lord, not counter affidavit, an affidavit pursuant to an order dated
Oh.
3/5.
The P. Nayak submits that he has filed an affidavit pursuant to the order dated 3/5/2024, passed by this court. Stop. Para registry to verify and place the same on the court. And list the matter on, when do you want?
Monday, my lord, next Monday.
Third,
Yes, third.
list something.
Obliged.
15.
Wait, is it, Lordship? Well, in this case, the petitioner school was provincialized under the 2011 Act. Well, even after provincialization of the school, the teachers of the school are not being paid their salaries till today. That is why, my lord, this petitioner school approached this honorable court earlier also. This court directed the authority to, my lord, examine their claim. But they have rejected the claim of the petitioner by the impugn order at page 100. Password of consent.
नाही.
Who is that order 6/5/2016?
My lord,
Communication 6/5/2016.
6/5. Page 78, my lord.
Page 70.
78.
Your school is
Chapurigao LP school, my lord.
serial number 3.
Yes, my lord.
So dice code of 2009 to 2010 is there,
Yes, my lord.
recorded.
Yes, my lord.
And where is the order?
Impugn order, my lord.
Yes.
Page 100, my lord. Authority part, my lord, 101, my lord.
Where's this court's order? 21/3/2022.
Last order is page 95.
Oh,
No,
Direction was given to the mission director lawsuit with SSA. Because dashboard is maintained by the SSA only.
no, 21/3/2022 in page 101. 101.
101 is the impugn order.
No, no. There's a reflection.
Page 96 is the order lawsuit that
3448 WBC 3448 2019.
2009.
this is the order, my lord, at page 96, my lord. By this order, my lord, it was disposed of, my lord. They have recorded the date, my lord, wrongly, my lord.
That perhaps that was
14,
wrongly.
14, 2021, my lord. In one place, they have recorded as 14/2021, my lord, page 100. Last but one paragraph.
Page 98, para 5 is the direction of the that particular case topic 3448 2021.
Who passed the order?
Impugn order passed with the director elementary. Impugn order.
Was it direction given to the director?
No, lawsuit. First direction given to the mission director lawsuit SSA. And if the order of mission director is in favor of the petitioner school, then director of petitioner within a period of 6 weeks, they have to sell to the need.
So where's the order of the mission director?
That mission director order,
no pass any order.
SSA will have to say to clarify lawsuit.
Yes. Bora? Whether mission director.
I
has
have filed
passed-
my, I have filed my affidavit, my lord.
No, whether mission director has passed any order. No.
No, mission director has not passed any order. Mission director has filed an affidavit in this case, saying that this particular school doesn't have the IS code of 2009, 2000.
No, no, you are the director to pass an order, reason order, in terms of page 98. Correct? Saikya?
Yes.
My lord.
Mission director is supposed to pass an order. Instead, the director elementary education passed the order. Is this sustainable in law?
Yes. I have to get the instruction, but in the meantime, my lord, I have that mission, that particular IS code of that.
That
I have
part
checked.
I understand.
But the
Come
order
to
has to
page 98.
Not this,
98.
lordship.
98 says mission director is directed to pass an order, reason order within 1 month. Have you passed the order?
But that instruction I don't. That I'll get the instruction, my lord.
One more aspect, my lord, I will like to draw your lordship's attention. The review, in the review petition, my lord, this honorable court held that the dice code is not the, my lord, fundamental requirement,
Yeah, that already is there.
my lord. So, my lord, even if the dice code was not there for the year 9-10, my provincialization cannot be, my lord, cancelled. Even till today, my lord, they have to cancel my provincialization. But my staff are not being paid.
That's all.
Yes, my lord.
You have been already provincialized.
Yes, my lord. Under the
But
11 Act,
then,
my lord.
Page 62, my lord, that particular order is last line, my lord. It is further provided that the order passed in the case, in the review petition, my lord, will not be treated as precedent to other cases.
But the ratio will be applicable, my lord.
That is specific. It cannot be a
The
precedent to other cases.
direction is not applicable, but the ratio decided.
No, that cannot be, my lord. This is for a particular.
Page 62, paragraph 9, if a lordship's, my lord, peruse the paragraph 9, my lord. Paragraph 9, page 62, my lord. In the review order, my lord.
that we've seen.
Yes,
That we've- The only thing is the operative portion of the final order passed by this
only
court.
pass a reason order lawsuit.
Did the mission director pass an order before the day?
No, I will get the instruction, my lord. I'll get it.
Let it come on next week, any date. No.
Third IS cycle and the council for the. Mr. S. Bora, Learned Standing Council S shall take instructions as to whether the mission director, SSA, isn't it, has passed a reasoned order in terms of the directions passed by this court on 4/10/2021 in WBC number 3448 of 2009.
One more aspect, ma'am. The order in this petition, 2/5/2024, my lord, an order was passed directing the director, my lord, to clarify the page 78. Thus will kindly peruse the order dated 2/5/2024, my lord. Because
Yes, you'll also have to take your instructions. You'll have to clarify the communication of 6/5/2016.
because if it is there, my lord, 9/10, the ICE code is there. They have not disowned this, my lord, communication.
In the meantime, the director of elementary education is also director. You file an affidavit. Director to file an affidavit
Clarifying this then.
clarifying under what circumstances the communication dated 6/5/2016 within bracket annexure 12 page 78 to the writ petition close bracket was issued, and whether the dice code shown against the name of the petitioner's school in the said communication dated 6/5/2016 is the dice code of 2009-2000. How long will you take?
2 weeks time.
Okay, this doctor, 2 weeks?
Yes.
They are not getting any benefit since 2013. School is provincialized, the staffs are not getting salary. Must we fix a date, my lord? Must we fix a date, my lord?
You want a date? Give a date after 2 weeks.
12th.
12.
My lord. Habla, sir.
12 days.
19.
Please, Your Lordship. Petitioner is the Hindi teacher of the particular school, Lordship. But in place of me, one science teacher is provincialized as showing as Hindi teacher, Lordship. Kindly see page number 33, Lordship. Serial number 4, the petitioner. And serial number 5 is the private respondent number 5, Lordship. He was appointed as a science teacher, and I am appointed as Hindi teacher, Lordship. But due to the mistake of the district elementary education officer, Lordship, page 38.
So that's why in the affidavit they've said that the
Revised
proposal has been
given.
sent.
Sent.
You're supposed to take instructions, Tutia.
And in this case, I have received instruction, my lord. As for new act, my lord, no proposal has been submitted, my lord.
What?
The revised proposal was submitted, my lord, as per the earlier act, my lord. After coming to the effect of new act, my lord, no proposal has been submitted.
My post was provincialized in the year 2013, Lordship. but provincialized with wrong person, Lordship. And this was done due to the mistake of the district elementary education officer. My name was sent showing as science teacher, and private respondent name was sent showing as Hindi teacher, Lordship. It's the gross mistake of the respondent authority, Lordship. And since 2013, Lordship, the private respondent of 5 had enjoying the all financial benefit in the post of Hindi teacher, Lordship.
Private respondent number 5.
5, Lordship. I have approached repeatedly before the respondent authority, but they have not taken any steps regarding correction of the name of Hindi teacher in the city school, Lordship. I am not entitled as per new act, Lordship. I have been provincialized, my post is provincialized as per 2013 12 act, Lordship.
Where is this revised proposal?
My lord, revised proposal was, my lord, as per the earlier act, my lord, 2012, that act is struck down by this honorable court, my lord. As per new act, my lord, the petitioner is not entitled, my lord.
So you want to proceed with the hearing? Respondent 6 has filed affidavit. How about you? Elementary education is
My lord,
filing.
we file our affidavit, my lord, after 2 weeks, my lord.
Okay, heard, Mr.
MK.
Learning Council for the MK new. MSS Jutia, Learning Standing Council Elementary Education Department. Press for 2 weeks time to file contract service. Press list after 2 weeks.
Okay.
20.
May please, your lordship. Here, my lord, the petitioner is a subject teacher of mathematics in a higher secondary school, and an uninformed salary has been deducted from his monthly salary for the month of January 2023. And when the petitioner approached the then principal in charge, he refused to provide any information as to why his salary has been deducted. And my lord, thereafter he sent an application via speed post, but that was also refused to accept. And thereafter, my lord, numbers of representation he had submitted before the concerned authority, but not a single representation has been disposed of. And now, my lord, after passing more than 1 year, they have got their instruction and stated that due to excess CL, his salary was deducted, my lord. But that was never communicated to the petitioner, and he was the then principal, who was subsequently resigned from his post of in-charge principal. He did not provide any information regarding deduction of payment, my lord. My lord, and that as stated by them that the
You file your affidavit?
Yes, your lordship. I
Yes.
would like to take you to
No,
our.
may I submit, my lord? No, they have filed their affidavit at a belated stage. Since, my lord, honorable court has directed them to file their affidavit latest by 30th of April, my lord. Darcy, may kindly see the.
I've seen.
Yes, my lord. So if your honor is accepting their affidavit, then my counter affidavit is necessary, my lord. That I have already filed yesterday, my lord. That is not in the
You
record.
file your reply?
Yes, my lord. I think yesterday I have filed it, but I
Let
think
it
it's
come on
not in the record. Yes, ma'am.
MS
P. Goswami.
P. Goswami, Learning Council for the petition. Submits that she has filed reply affidavit to the affidavit in opposition filed by the respondent number 2 on 27/5. Registered to verify and test the sender of the report. List after 1 week?
Yes, ma'am.
List after 1.
Can you date me fix me?
10th.
Yes, ma'am. Obliged, ma'am.
21, 22.
May I please, your lordship? Lordship, we are in the third round of litigation for the similar grievance that we raised.
Lordship, she was a professor lecturer appointed in 1995. In 2001, there's an advertisement where she was to be promoted to the post of reader. So she was short by 6 days as it was at that point of time, the rules. So she made an representation before the then Vice Chancellor Lordship at page 22. That is a type copy, Lordship, page 22. Lordship found it below, Lordship, we have made. There is a note of the Vice Chancellor allowing us to apply for the, by waiving that shortage of 7 days, Lordship.
Yes.
Then we have made the application. However, the application was not processed, though others application, the similar candidates were processed. So we filed the representation before the EC and Registrar and the Vice Chancellor. Then it culminated in a committee report, Lordship, at page 24, that is type copy.
No, after this, after you allowed,
We have applied as per the advertisement that was issued in December of 2001. The petitioner application was not considered by the committee or the university itself. It was not processed for consideration to be promoted to the post of reader in 2001. And they have ignored the relaxation given by the Vice Chancellor. Eventually, we filed a representation and it culminated in a report which was called for by the committee. That is at page 24, Lordship. That is the first report. Page 24 is a type copy, Lordship. 25 is the copy. There's two recommendations. If Lordship sees the second recommendation, the committee's Office of the Registrar, Guwahati University, committee report regarding case of Dr. So-and-so, that is the petition, Lordship. Point number 2, the recommendation number 2, we also recommend that Dr. J.B. Rao promotion to the reader scale be considered with effect from 2002 as per GU rules with immediate effect. That is, all other batchmates of the petitioner were promoted as per in that year, 2002, Lordship. But they have not again given any effect to that. And we have filed another representation in page 26.
this is what committee?
That is a committee formed by the registrar with regard to the representation filed by the petitioner, Lordship.
Petitioner is
Just the Raut, Lordship. And that was not given effect to, and we filed another representation in page 26. We write to the registrar again, Lordship, then page 28 to the Vice Chancellor, that is in 2012. Eventually in 2017, Lordship, that is page 30. As per our representation, a committee was formed by the Executive Council, Lordship. Lordship says it is notified for information of all concerned that pursuant upon a decision of the Executive Council, Guwahati University in its meeting held on 17/2/2017, a committee with the following members constituted to examine matters regarding promotion of the petitioner.
Yes.
Lordship, that committee was formed. Now the committee comes to a report at page 31. Lordship allows me a lot.
Yes.
I would like to read the entire report, Lordship, because that will.
Entire report.
Otherwise, Lordship, if Lordship comes to page 33, the observation, because report itself says how they have flouted the orders given by Chancellor, Vice Chancellor, and the Registrar, Lordship. That is at page 32. I'll just take one paragraph, Lordship, page 32. From the first paragraph, Lordship. From the record, it appears that the concerned department and the Office of the Registrar ignored waiver of 7 days, shortage as on 31/3/2001, allowed by the then VC HL Duara. Though the applicant Dr. Rao submitted VC's note dated so-and-so to the HOD, then Registrar of GU, our application dated so-and-so was also ignored. Being aggrieved, she took up the matter with Registrar and proposed to follow up her claim with an appeal to the Honorable Chancellor, with a copy of her application received from the Registrar. The Honorable Chancellor directed GU Authority to consider her promotion with effect from 2002. But GU Authority did not comply with the Chancellor's direction, Lordship. Thereafter, Dr. Rao repeatedly applied for promotion, but her applications were not processed for 5 years. Dr. Rao approached the Honorable Chancellor once again, who directed the VC to conduct an inquiry, Lordship. That inquiry report is this one. And the recommendations, observations were at page 33, Lordship. That observe on perusal of all documents concerned, advertisement, correspondence, and statements, the appellant committee observes as under. After the observations were given, Lordship, there's an issue at page 35, Lordship, that meeting or Executive Council meeting was held, which also resolved the
What
matter
was
of
the recommendation?
Lordship.
Recommendation of the committee?
Lordship is page 33. There total as of total 8 recommendations, Lordship, with regard to the same matter, Lordship. If Lordship allows me, I'll take you through. Otherwise, I'll take to the EC resolution at page 35, which resolved to consider a promotion once again from as per 2001 advertisement, Lordship. Page 35, that is a relevant part. We have typed it out. And as nothing was done, Lordship, we approached this honorable court. This honorable court at Lordship will page 64.
Page
64. We approached this honorable court in 2001. That is the order. Lordship come to page 65. Honorable court has taken note of the observation that I was just referred to of the committee and directed. The observations were taken note of at page 65 and 66, Lordship. And thereafter passed in direction at this page 67, Lordship, if I may read, Lord. Considering the limited grievance raised as by both Mr. R. Majumdar, Learned Counsel of the petitioner, as well Mr. P.Z. Fukan, Learning Standing Counsel of the Guwahati University, the claim of the petitioner for promotion as leader from the year 2000 to be again placed before the Executive Council in order to enable Council take note of the recommendation of the committee. That is the committee that I've just referred to, Lordship, the recommendations. Dated so and so. This writ petition stand disposed of directing the authorities in the Guwahati University to once again place the claim of the petitioner for promotion with effect from 2002 before the next available meeting of the Executive Council of the Guwahati University. Now, the committee, we have filed a representation stating about the order passed by this honorable court, and the committee comes up with a resolution at page 70, Lordship. The lower part, Lordship. Resolved that the earlier decision of Executive Council meeting held on so and so in relation to change of date of effect for promotion of Dr. Josna Vispal Raut to the position of reader be not considered for reviewing. And as such, the earlier decision be in force in connection failing, which there might be cascading effect beyond the control of the university. Challenging this resolution, we once again come before this honorable court, Lordship. That is at page 73, 72 is the order, starting part. The effective part is, Lordship, at page 74. The honorable court again remands back the matter to the Guwahati University. That is at paragraph number 5. In view of the above matter is remanded back to the Executive Council for a fresh consideration by complying with the requirement of judgment dated 12/1/2021. That is the order at page 64. That is basically to consider the recommendation of the university, then consider the case of the petitioner. Otherwise, other aspect, the report committee was not considered and the reason order passed thereon. We are not expressing any view on other provisions. After that, they have passed the Lordship resolution at page 75, which is under challenge in this writ petition, Lordship. Now, Lordship has found at page 75. That is the resolution they have come after the order. If I may read, Lordship.
Yes.
I'll read from the second paragraph, Lordship. The Executive Council discussed the matter in light of the following note, which was placed in the hearing in the meeting. The notification under memo number so and so invited application for the purpose of personal promotion of university teacher period to be covered up to 31st March 2001 in pursuance of the provisions of Guwahati University rules for personal promotion of the university so and so. There is no dispute with regard to rule having 6 years as on 31/3/2001. That was, we prayed before the authorities to waive off, which was waived off. The issue is not considering the recommendation of the VC, the chancellor, and even the committee recommendation of the formed by the Executive Council, and also the order of this honorable court directing to consider the recommendation. So what they have come to resolve is that there is a law, there is a resolution, there is a rules of the Guwahati University that 6 days cannot be waived off, and that is being spoken of after everything. All other authorities are directed to consider the waiver given by the vice chancellor. That is the premise of challenge for us, Lordship. They have ignored all directions, as I've indicated, I've shown in the report, Lordship. They have ignored the vice chancellor's report directions, waiver, the chancellor's direction, the honorable court's direction, and also the executive committee's direction, Lordship. And it is done by the another executive committee, Lordship. So that is a challenge, and they have not come up with any reason which says that that cannot be waived off. The report also says there are situations where such waiver was given to other candidates before, at that point of time. And Lordship, that is of 2001. And now we are in 2024. She is at the fag end of her career. And she is not fighting for monetary purpose or any other benefits. It is the right of the petitioner that ought to have considered at that point of time. And she has availed all possible channels she had at that point of time. And at the time of advertisement, that was in December, she already completed 6 years. Only she was 7 days shortage as it was given in the rules, 31st of March 2001, the year of advertisement, not on the date of advertisement. And also if Lordship sees the resolution, they relies on there is nothing in says why they have not considered. They only said there's the rules. Of course, there are rules. That's why she had applied for a waiver, Lordship. And that is my humble submission that resolution itself has no reason why it was not considered.
What does the resolution say?
Lordship, the final part is at Lordship, page 76. Resolve that the facts presented in the note above justified and be approved for the necessary action appraisal to the Honorable Court in respect of WPC number so and so, the earlier repetition, Lordship. They've come up that say that there is a legal opinion that cannot be considered. There is judgments of the Honorable Court that cannot be considered. There's no reference of any judgments or anything, Lordship, in that. And even in the affidavit, there is no reference to any judgment. They've simply relied on the paragraphs given in this resolution, Lordship. And the resolution is observation of the committee, Lordship, what they have observed. In fact, they discusses of the scheme of 2004, which is completely not relevant, Lordship, because issue is of 2001 and 2002.
Yes.
My humble submission is the existence of rules, what they discuss in the resolution that are under challenge. It is not in dispute, even not in dispute in 2001.
What are rules?
The rules they are referring in page 75, that is paragraph number 3, Lordship. Guwahati University rules for personal promotion of university teachers, 1978. That mandated 6 years as on 31/3/2000 of the year of advertisement. 31st of March of the relevant year of the advertisement, a candidate must complete 6 years, Lordship. She was short by 7 days. She has prayed before the Vice Chancellor, the Chancellor, everyone. Each office has waived of those 7 days, Lordship, and directed to consider her promotion from 2002. That is the advertisement was issued in December 2001, Lordship, which was ignored by the university authorities throughout the entire period, Lordship, of 23 years. There is a recommendation of the executive committee, the Chancellor, the Vice Chancellor, the Registrar Office, but they have ignored it. And finally, they come up and say there is a rule. Existence of rules had mandated for the petitioner to file the application for waiver, which was allowed, Lordship. And Lordship, and they have not said the Vice Chancellor did not have the authority to waive. They're only saying if in paragraph 76, Lordship, if Lordship take paragraph number 2, they only say it is surprising that the aforesaid committee laid unwarranted stress upon the purported waiving note. Seven days of shortage.
You're reading from?
Paragraph, page number 76, Lordship. Paragraph number 2. They do not say that no one has authority. It is surprising that the aforesaid committee laid unwarranted stress upon the purported waiving note of 7 days shortage of experience that to made prior to said notification dated 13/12/2001, while at the same time maintaining deafening silence about the provisions of the aforementioned GU rules. As the said notification where the cutoff date was fixed on 31st March of the year concerned. That is admitted position. We are not saying that is not, we said we prayed. VC has allowed, the Chancellor has allowed, the committees has allowed. And only this committee talking with another committee of the same strength, Lordship, saying they are placing unwarranted stress. The committee is not higher in rank or they're not having sitting as an AP.
What is this notification of 13/12/20?
That is the advertisement calling for the candidates for applying to the post of reader, Lordship.
Where's that advertisement?
That I do not have the copy, Lordship. That we never had the copy as of, but that is the admitted, not disputed. When they admit, we also say at that point of time we applied. And what we challenge is that Vice Chancellor having the authority. They're not saying that he did not have the authority. And there is no reason why they have ignored the directions of the Vice Chancellor or the Chancellor, even the committees, executive committee, even the order of this Honorable Court at page 64, Lordship, where the Honorable Court has directed clearly to consider the recommendation and then take up the case of the petitioner for promotion, Lord, which they have ignored. They're only stating it might have cascading effect. Now they're stating there is a rule of course in existence. That's why we applied for waiving of the 7 days, Lord.
Where's this rule?
Rule copy that is not available. We have tried to find in books also. That is
You
not.
have a copy of the rules?
He would
No,
provide
my lord,
you.
I don't have the copy.
You should have the rules.
My lord, I definitely the university has got that rule.
You have to see that particular rule.
That says, Lordship, that it should be 6 years. That is no
77
dispute.
is clear, my lord, regarding that rule.
That we also do not dispute with regard to that. That it ought to be 6 years on 31st of March of the relevant year of advertisement. But the issue is the Vice Chancellor waiving it off and they ignoring it. Chancellor directing them to consider, they are ignoring it.
If your
The
lordship
committee
desires,
is
my lord,
directing.
I will, my lord, submit the, furnish the rules, my lord, on the next day.
Rules, we are not disputing with regard to that.
No, I want to see the rules.
Lordship.
You finish the rules.
My lord.
Lordship may have it early there because she is in the fag end of the career. She will be retiring.
When is she retiring?
Next year sometime, Lordship, if I'm subject to her.
But Mr.
D. Decca, Lordship.
The Deccal and the Council application. Mr. P.G. Fukan and the Standing Council Guwahati University shall furnish a copy of the
Personal promotion of university teachers rule, 1978, page 77, my lord.
copy of the Guwahati University personal promotion
Rules for personal promotion of university.
shall furnish a copy of the rules for personal promotion of university teachers, 1978. Stop. List the matter on
Maybe next Thursday, next Tuesday, Lordship, any that, if Lordship convenience, Lordship.
Next Thursday, my lord.
That is day after tomorrow. The next Thursday.
Next week, next. On 6th, my lord.
6th.
Yes, Lord, 6th.
24.
Obliged.
Most obliged.
Yes.
May I please? My lord, this writ petition is to rest on a very short point, my lord. And it relates to, my lord, the Assam High Secondary Council, which is a statutory body, my lord, having been constituted under the Act, my lord, Assam High Secondary Education Act. Now, all the respondents, my lord, are represented by the Standing Council of the, my lord, Council, my learned friend. Now, here, what has happened, my lord, the Council, my lord, which is the highest body, after, in terms of the regulation, my lord, holding the field, it upgraded my post and, my lord, promoted me to the post of Deputy Secretary, Information Technology. Way back in 2019, the proposal was mooted out in 17. And thereafter I was appointed, man, but albeit on interest basis. Now, while, my lord, serving in that post, after a period of 5 years, my lord, from the date of promotion, now a resolution has been moved, my lord, to cancel my promotion.
After 5 years.
5 years. And that too, my lord, my only submission is, my lord, while cancelling, my lord, my promotion, the ground is, my lord, that the present service regulation, which, my lord, has been enacted by the council, that does not, my lord, provide for promotion in a single cadre post. This is, my lord, the point, my lord, which they have taken, my lord. Now, the only point which, my lord, is involved is, when this decision, my lord, has been taken, the regulation, my lord, which was brought in, that has not received, my lord, the sanction of the government, and it was not published in the official gazette.
which is a requirement under the Act. The Act says, my lord, that in case of revocation or in case of, my lord, introduction of new regulation, that must receive the assent of the government and it must be published in the official gazette. Now, the affidavit which has been filed, my lord, that has been admitted. So therefore, entire, my lord, decision is based on a non-existent fact. Therefore, my lord, it is irrational. And your lordship is aware, my lord, in public law domain, my lord, a public body or, my lord, an administrative authority, when, my lord, they have the power, my lord, to take a decision to the prejudice of somebody, my lord, judicial scrutiny is permissible on 3 grounds. Number 1, illegality. Number 2, procedural impropriety. And number 3, irrationality. Irrationality is a ground your lordship is aware when relevant considerations has been, my lord, discarded. And the entire decision, my lord, is based on some irrelevant or non-existent fact, my lord. So here a decision has been taken on the, my lord, regulation which has not yet come into force. If your lordship takes up the affidavit, I'll directly take your lordships to the affidavit filed by the council, my lord. This is the entire crux of the matter, my lord. That starts from page 97. And if your lordship comes to para 5 at page 99, they have in no uncertain terms, my lord, that is admitted. They have sent the proposal, but it has not been received yet. Para 5, that with regard to the statements made in para 4 and 18 of the writ petition, the deponent begs to state the AHSEC Regulation 21 was framed and the regulation is in force on the date from 4/1/22. So far allegation made in those paragraphs that regulation framed by the council would require approval of the government. The revised service regulation has already been sent to the government for its approval by this office letter dated 1/2/22, but no communication is received from the government in this regard. Now, if your lordship comes to my writ petition, lordship will come to the impugned, my lord, decision at page 93, annexure 13.
Yes.
The relevant part is at page 94. Your lordship will see page 93. My lord, this is a meeting on 31/3/23. They have filed this affidavit. January 9th, 2024. Till date, my lord, till filing of this affidavit, my lord, no approval from the government was received. So admittedly, when this impugned decision was taken, the new regulation did not come into force. And if your lordship takes up the act, this act is very specific. It's a statutory requirement, my lord. Section 24, deduction. Your lordship will see section 24, powers of council to make regulation. 24(1), the council may, subject to the approval of the government, make regulations for the purpose of carrying out the provisions of this act. Now, if your lordship turns the page and comes to the proviso of section 24, next page, my lord, proviso also makes it very clear. Provided that in the regulations, alterations and revocations thereof shall be subject to approval by the government and published in the official gazette. My lord, this is a mandatory requirement. In respect of other, my lord, rules and regulations also, your lordship is aware that it is published in the official gazette because it's a public notice. The citizens are made aware that this is the rule which has come about. And this, my lord, particular provision has to be constituted to be mandatory, my lord. It's an act, it's a statutory provision, my lord. So my humble submission, my lord, when this impugned decision was taken.
Let us see the decision.
Yes, my lord. It is at page 93, my lord. And the relevant part is at page 95.
94/5.
95, my lord. Page 95. It starts from page 94. I can take your lordship to the page 94, my lord, which starts from item number 149/23/9.
Item number?
The last item number 149/23/01/9. This is the my lord, item in respect of the present my lord petitioner. Consideration of the recommendations of the administrative committee held on 21/3/23. Read the proceedings of the meeting of the administrative committee held on 21/3/23. The council resolved that all the recommendations made by the administrative committee held on 21/3/23 be approved. Regarding item number 1 of the administration proceedings, the secretary informed the members that the earlier council in its meeting held on 21/3/18 approved promotion of Sri Arpan Kumar Bormon. Lordship will take note of my lord the date in 2018 itself. Academic officer, academic computer to the post of Deputy Secretary Information Technology. Though the council approved promotion of Sri Bormon, his case was not considered at that time. In the meantime, page 95, my lord, the service regulation of the council has been amended and service condition of the post of Deputy Secretary Information Technology were also incorporated in the revised service regulation. But as the post of the Deputy Secretary Information Technology being a single cadre post, the council in its meeting held on 12/8/22 decided to fill up the post of Deputy Secretary through open advertisement. The secretary further informed the House that the administrative committee held on 21/3/23 observed that decisions adopted by the council in its meeting held on 29/3/18 and 12/8/22 were found contradictory. Hence, the administration committee arrived at consensus that the resolution adopted by the council in its meeting held on 12/8/22 needs to be reviewed, and the committee suggested to place the matter in today's meeting of the council. Now, this is next, my lord, this is the operative part. The council heard the secretary, also heard the chairman, and perused the revised service regulation. The entire decision is based on revised service regulation of the council. And after thorough discussion, the council declined to consider promotion of Sri Arpan Kumar Bormon, academic officer, academic computer to the post of Deputy Secretary Information Technology. Now your lordship will see, my lord. As the revised service regulation does not permit promotion to such posts as it being a single cadre post. However, the council accepted appeal of Arpan Kumar Bormon, academic officer, for legal justice. The council further resolved that the post of Deputy Secretary be filled up as and when it becomes necessary for the council. So therefore, what they essentially say that the new service regulation which has been framed, it does not permit promotion in respect of a single cadre post. And therefore, my lord, my promotion, which was affected in 2019, that has been nullified now. And what was done, my lord? I'll show from the materials on record. My post was upgraded to the post of Deputy Secretary. The post which was being held by the petitioner, that was abolished. Appointment letter was issued at page, my lord, 78. This is of 37/2019. But what they did not, my lord, issue a substantive appointment letter. They allowed me to hold, my lord, on in-charge basis. If your lordship comes to page 78, from 2019, I'm holding this post, my lord. As per resolution of the council in its meeting held on 30/10/2017, your lordship will see, my lord, this language. As per resolution of the council, my lord, it's the highest body. It had taken a resolution, my lord. And thereafter, I was appointed. Arpan Kumar Bormon, academic officer, is placed in the IT section as in-charge Deputy Secretary, Information Technology, to look after the following activities of the council. Now, I was working, my lord, from 2019, my lord, till date. Right now, I'm working because, my lord, this honorable court has passed an interim order, my lord, not to my lord, issue any advertisement to fill up the post, my lord. Thereafter, my lord, your lordship will see, interestingly, actually what had happened.
This is your upgradation order.
This is my upgradation orders are different, my lord. There are different upgradation orders. This is, my lord, eventually the appointment order. Upgradation order, your lordship will find. Firstly, your lordship will find page 67, annexure 5. This is the meeting of the council, my lord, on 30/10/2017. And if your lordship comes to next page, page 68. Now, third para, under item number 8A of the administrative committee held on 16/10/17. There is already an administrative committee meeting, my lord, which was held on 16/10/17. The council unanimously approved
creation of the following two posts of deputy secretary. A, deputy secretary registration, permission, recognition, that is another post which was already filled up, and this person is working, my lord. And B, deputy secretary, information technology, my lord. This is the post, my lord, which was to, the petitioner was upgraded. Now, if your lordship comes to down below, above, my lord, the penultimate paragraph, above the penultimate paragraph, for deputy secretary, technical information technology, the academic officer of the council be upgraded to the rank of deputy secretary if otherwise eligible. So this is, my lord, the resolution of the, my lord, council of the meeting held on 30/10/17. Thereafter, your lordship will come to next page. Sorry, my lord, the next resolution of the administrative committee. This is important. Page 71, Annexure 6. The relevant part at page 72. Your lordship will come to the last proposal, E, regarding proposed technical and IT branch. Your lordship has got it, my lord. Now, this reads as follows. The secretary informed the committee that for improvement of technical IT branch, Sri Arpan Kumar Burman, that's the petitioner, academic officer computer, may be promoted to deputy secretary, technical and IT as approved by the council in its meeting held on 30/10/17, the earlier, my lord, meeting. Hence, the matter was placed before the committee for consideration. The committee considered the same, heard the secretary and the chairman, and after thorough discussion, recommended that Sri Arpan Kumar Burman, academic officer, be promoted to the post of deputy secretary and the post of academic officer be abolished. This is the resolution, my lord, of the administrative committee. Subsequent to this, my lord, the meeting at page 74 of 29/3/18, this recommendation was approved by the highest body, that is the council, my lord, on 29/3/2018 at page 74. The relevant part, your lordship will kindly come to page 75. Last part, under item number 7B. The newly created post of deputy secretary RPR and academic officers be filled up immediately through open advertisement. This is not necessary, my lord. Your lordship will come to page 76. Next part, this is relating to me. The council resolved, your lordship has got it, my lord. The council resolved that as the council in its meeting held on 30/10/17 approved promotion of Sri Arpan Kumar Burman, academic officer, to the post of deputy secretary, Sri Arpan Kumar Burman be promoted and post of academic officer be abolished immediately after his promotion. These are the resolutions, my lord, back to back, promoting me, upgrading me, and abolishing my post. Thereafter, my lord, comes this appointment order at page 878, which I have drawn your lordship's attention, 37/2019. And from this date, my lord, I have been working. Now, interestingly, if your lordship takes note of one aspect of the matter, this will make everything clear. Page 74, when the resolution was taken, and in its earlier resolutions, my lord, if your lordship sees the members, the chairman is one Dayananda Borgohai, and the secretary is one Sri Kamal Gogoi. The board, the council was constituted of this chairman and secretary. My lord, the entire resolutions, my lord, were taken, my lord, by the chairman and secretary and the other members. Subsequently, if your lordship comes to page 79, when the things started moving, my lord, against me, there is a change, my lord, in the guards. And this will indicate, my lord, the malafide intention on their part. The chairman has changed and the secretary has changed. These are two different persons. Now, the question is whether a valid decision, my lord, can automatically change when there is a change in the, my lord, office. And that too, when the resolution, my lord, is based on a non-existent fact. And therefore, my lord, it is irrational. And on that count, my lord, it is a instrumentality of the state within the meaning of Article 12. So therefore, the decision has to conform to the norms of, my lord, fairness, my lord. And this is a fit case because having been, my lord, promoted in 2019, having allowed, my lord, to function on the ground of requirement, there was a necessity, my lord. And thereafter, after 6 years, my lord, you suddenly take a decision and thereafter you say that your promotion is nullified. And that too not, my lord, on any cogent grounds. A statutory, my lord, requirement
my lord, has been wholly ignored. To have, my lord, a sanction of law, your resolution must have the approval of the government, and it must be published in the official gazette. In absence of that, my lord, the resolution does not acquire the force of law. So therefore, when you nullify my promotion on the basis, my lord, of a resolution which does not have the sanction of law, your entire decision goes. On this ground itself, in my respectful submission, my lord, the decision to nullify my promotion is required to be, my lord, set aside by this honorable court. And in their affidavit, my lord, they have made it very clear that it has not been received.
What does it say, this page 95?
My lord, page 95. Page 95 says the relevant part. I'm again reading it out. My lord, the third paragraph. The council heard the secretary, also heard the chairman, and perused the revised service regulation.
That is the one which is not yet approved. By
Exactly, my lord. Of the council, and after thorough discussion, the council declined to consider promotion. Once already it has been, my lord, decided. I have been promoted. Where is the question of declining, my lord? Of Sri Apan Kumar Burman, academic officer, to the post of deputy secretary, as the revised service regulation does not permit promotion to such post as it being a single cadre post. My lord, this analogy is also, my lord, erroneous. Because if the regulation permit as a proposition of law, my lord, there is no embargo to promote, my lord, in a single cadre post. Yes, the embargo is in respect of reservation. A single cadre post cannot be reserved. But unless, my lord, it is barred or there is an embargo under the regulation, my lord, as a proposition of law, my lord, it is not final. There is no such law that a single cadre post cannot be, my lord, filled up by way of promotion. And that too, a resolution, my lord, which has not come into force. So therefore, on both count, as a proposition of law and as an analogy, my lord, because it is based on a non-existent fact, the resolution has not come into, my lord, force till date. On this ground itself, my lord, it goes. It cannot sustain, my lord.
And the third para, the next paragraph?
Yes. However, the council accepted appeal of Sri Apan Kumar Burman, academic officer, for legal justice. I submitted representation because what has happened after my appointment in 2019, I said that there are resolutions of the highest body and there is a statutory mandate that when a resolution, my lord, is passed, the chairman and the secretary is duty bound to, my lord, implement that resolution. If your lordship comes to, my lord, section 20, sorry, my lord, section 19, power and duties of the chairman. Therefore, the resolution, my lord, it acquires a statutory force. Section 19, power and duties of the chairman. Your lordship has got it, my lord. It shall be the duty of the chairman to see the provisions of this act and regulations make under it are faithfully observed, and the decisions of the council are duly implemented. And he shall have all the necessary powers for this purpose. So the decisions are required to be implemented. Now, when the decision is taken to upgrade my post, to promote me, my lord, to the post of deputy secretary, why don't you issue an appointment letter in terms of section 19? How can you allow me to continue on an in-charge basis in absolute violation of the mandate of law? My lord, the entire decision is arbitrary. It cannot sustain. And it's a public body. It cannot act in this manner, my lord, as he has, my lord, acted. A judicial scrutiny, if it finds, my lord, that the decision is based on a non-existent fact, it cannot sustain. On this count, my lord, I rely on a Supreme Court judgment with regard to the option. This is, my lord, in respect of appeal of income tax, but, my lord, the proposition in respect of the judicial review of administrative or executive action, my lord, has been discussed by the Supreme Court. If your lordship comes to para 11,
Yes.
my lord, I am reading it out. By now, the parameters of the court's power of judicial review of administrative or executive action or decision and the grounds on which the court can interfere with the same are well settled, and it would be redundant to recapitulate the whole catena of decisions of this court, commencing from barium chemicals, Air 1967 Supreme Court, so-and-so, case on the point. Indisputably, it is a settled position that if the action or decision is perverse or is such that no reasonable body or persons properly informed could come to or has been arrived at by the authority misdirecting itself by adopting a wrong approach or has been influenced by irrelevant or extraneous matters, the court would be justified in interfering with the same. This court, in one of its later decision in Srimati so-and-so, has observed, it is an unwritten rule of the law, constitutional administrative, that whenever a decision-making function is entrusted to the subjective satisfaction of a statutory functionary, there is an implicit obligation to apply his mind to pertinent and proximate matters only, eschewing the irrelevant and the remote. Suffice is to say that the following passage appearing in so-and-so succinctly summarize the several principles formulated by the courts in that behalf. The authority in which a discretion is vested can be compelled to exercise the discretion, but not to exercise it in a particular manner. In general, a discretion must be exercised only by the authority to which it is committed. The authority must genuinely address itself to the matters before it. It must not act under the dictation of another body or disable itself from exercising a discretion in each individual case. In the purported exercise of its discretion, it must not do what it has been forbidden to do, nor must it do what it has not been authorized to do. It must act in good faith, must have regard to all the relevant considerations, and must not be swayed by irrelevant considerations, must not seek to promote purposes alien to the letter or spirit of the legislation that gives to act, and must not act arbitrarily or capriciously. Nor where a judgment must be made that certain facts exist, nor where a judgment must be made that certain facts exist, can a discretion be validly exercised on the basis of an erroneous assumption about those facts. Here this says, my lord, that it cannot be, my lord, exercised on a non-existent fact. These several principles can be conveniently grouped into two main categories: failure to exercise a discretion and excess or abuse or discretionary power. The two classes are not, however, mutually exclusive. Thus, discretion may be improperly fettered because irrelevant considerations have been taken into account, and where an authority hands over its discretion to another body is ultra vires. Nor it is possible to differentiate with precision the grounds of invalidly contained within each category. So, my lord, my submission is, when the irrelevant decisions has been taken into account and the relevant factors, my lord, which are german, has been excluded, the decision becomes irrational. And here, my lord, a regulation has been relied on which has not yet come into force. So therefore, the entire decision, my lord, rests on a non-existent fact. And therefore, it has been rendered perverse, my lord, and irrational. Now, this is a public body, my lord. Public body cannot act in this manner. It has to conform to the norms of fairness. Therefore, in my humble submission, my lord, this decision is liable to be interfered with. I have been already promoted in 2019. So my substantive promotion, my lord, should be from 2019. Your lordship may clarify it. This is my humble submission, subject to what my learned friend says.
Maybe. So for the submission made by the learned counsel, as for the factual part, that is correct, your lordship. Factual part. But one important part he has not submitted before this honorable court. That is at page 80, your lordship. Just the technical reasons why that post of promotion could not be considered. Page 80. Item 9. Item 9, page 80. The secretary informed the member that the council in meeting on 29/3/2018 resolved to promote Sri Arpan Kumar Burman, academic officer, to the post of secretary, technical and IT for improvement of technical and IT branch. However, promotion could not be made effective as there is no post of deputy secretary in the regulation of the council. The earlier regulation, there is no post. Earlier, that is the 85 regulation is there, but in that regulation, the IT post is not there. And so that is the main reasons that the council.
What about this next paragraph?
The committee heard the secretary, also heard the chairman, and after detailed discussion, the committee was an option that the post of deputy secretary technical IT being a single cadre post, the post would be filled up through open advertisement. So it becomes a single cadre post after 21.
After?
After 21, because the 2021, there is another new regulation come. And
That regulation has not come into effect, isn't it?
Yes, the approval is not there.
Then
Government approval is not there.
Then you can't act on the basis of that resolution.
That is there, your lordship. Only the reason is that they are taking this advantage that the post is that does exist in 85 regulation.
There's no post of.
No post of.
Then how have you given him in charge deputy secretary?
That has been created later on.
So there's a creation of posts, isn't it?
Upgradation, man.
That was upgraded.
Upgraded.
No.
My post was abolished. It was upgraded. The decision shows.
No. The deputy secretary IT was created on 16/10/2017, page 65. The committee considered the same and heard the chairman, appreciate the proposal of the chairman, and after detailed discussion, approved creation of two posts.
So approval was given for creation of two posts of deputy secretary.
Yes. The approval
One is registration permission and the other one is concerned with the petition. Yes. Correct.
Yes.
Was there a creation? After this approval, was there a creation of post? No, there was no creation. Only the post held by the petitioner was upgraded to the post of deputy secretary.
Yes.
There was no creation of post.
No,
And you abolished the post which was earlier held by the, these are two issues, very important issues this.
Yes.
Here there is an approval for creation of two posts,
Yes.
but there's no creation. Approval was given, but there was no creation. Instead of creation, you upgraded the post of what post were you holding the time?
Academic officer.
Academic officer.
Computer.
Computer.
It is there, your lordship. It is there.
Correct.
Your lordship. Because of only for these technical two reasons that it is does not exist in the 85.
That is not the issue. See, you have abolished the post of academic officer. No, you have upgraded the post of academic officer to the post of deputy secretary.
Yes.
And abolished the post of academic officer. Correct.
Yes, yes.
So obviously there was no creation of post. It was an upgradation of post.
Here the say all are in confusion.
No, there's no confusion. There's no room for any confusion here.
No, the secretary or the chairman are in confusion because the council meeting, it is the highest body. That has not permitted.
That has?
That has not permitted to upgrade him.
After the council meeting that was upgraded, all these meetings, my lord.
Where was that? Where was that?
2017, from 2017, if your lordship comes to page which my learned friend is referring to.
Page 67.
Page 67, my lord, this is the council, my lord, it's the highest body.
Page 68.
Page 68, my lord. Yes. This is taken by the council all along. These proposals are being taken by the council itself. Then subsequently, when the chairman and secretary changes, my lord, these are reversed. How can it be, my lord? This is what is happening. They take a decision themselves and thereafter they reverse, my lord.
Page 94, your lordship. Page 94, last paragraph. Because of that resolution, they are in confusion.
This is the impugned resolution which I have drawn your lordship's attention, my lord.
Come to page 72.
70.
Two. This is a minutes of the administration committee.
Yes. It is there, your lordship.
Academic officer is abolished.
May be promoted to the deputy secretary, I think. So it is there, your lordship. Only because of the confusion of the council meeting and the administration committee meeting, that is in stage 80, they could not take any decision to upgrade.
So according to you, what is your submission?
It is up to your lordship, up to your lordship.
Absolutely arbitrary, my lord. He has no submission at all. This is their own decision. They have taken a decision. Subsequently, they reversed it without any cogent reason, without any basis, man, and totally on a non-existent fact. I have shown your lordship, man. This is only on this particular point itself, short point, because a statutory requirement, man. It has no sanction of law. They cannot change it in this manner, my lord. Absolutely arbitrary, my lord. Cannot do that. And after allowing me to work for a period of 6 years, my lord, from 2019 itself. Public body.
You will dispose it of. Well. But Mr.
S.K. Talukdar.
S.K. Talukdar also heard Mr.
NN Upad.
NN Upadhyay. Learned Standing Council.
Yes.
Assam Higher Secondary Education Council. For all the responses. Stop. For the petitioner was appointed as assistant secretary within bracket academic dash computer under the Assam Higher Secondary Education Council. Within bracket, we say council in short. Here and after council in short. By you are appointed by which order?
My lord, I was appointed by, your lordship will find my order at
Lecture 3.
page 63, my lord. Annexure 3, 1998, my lord.
By an order. Dated 1998. Issued by the secretary of the council. Stop. It was redesignated later on.
Yes, my lord, academic officer.
The post of assistant secretary within bracket academic dash computer was redesignated as academic officer
Computer.
within bracket academic dash computer. Is in order, order is in
That order is not part of the record, sir.
by the council. Stop. While the petitioner was serving as such, comma, the administration committee of the council in its meeting held on 16/10/2017 at item number 2, at item number 8. Approved for creation of 2 posts of deputy secretary for the branches within bracket A, you say registration, permission and recognition. And within bracket B, technical and IT. Stop. Thereafter, the council in its meeting held on 30/10/2017
Page 68, my lord, item 80.
under item 8 within bracket capital A. Took a decision, resolved to upgrade the post of academic officer within bracket academic dash computer to the rank of deputy secretary within bracket technical and IT if otherwise eligible. Stop. Para. The administration committee of the council in its meeting held on 21/3/2018 recommended the petitioner to be promoted to the post of deputy secretary within bracket technical and IT and the post of academic officer within bracket computer be abolished. Stop. The council in its meeting held on 29/3/2018
Page 76, my lord.
under item number 7 within bracket E. Resolved approved the promotion of the petitioner to the post of deputy secretary within bracket technical and IT and the post of academic officer within bracket academic dash computer be immediately be abolished immediately after the promotion of the petition. Stop. Para. Consequent to the resolutions passed by the administration committee as well as the council in it, comma, the secretary of the council issued an order dated 30/7/2019 in terms of the resolution of the council meeting held on 30/10/2017 by placing the petitioner in the IT section as in charge deputy secretary within bracket technical and IT to look after certain activities of the council. Stop. After that, you made representations.
I made representation because, my lord, I was not given the substantive post.
Stop. As the petitioner was not given the substantive, was not given promotion.
Yes, substantive, on substantive basis.
On substantive basis.
My lord.
To the post of deputy secretary within bracket technical and IT. He made representations before the concerned authorities of the county. Stop. Accordingly, comma, the administration committee in its meeting held on 5/8/2022 no, it don't say. However, cancel the whole. The administration committee in its meeting held on 5/8/2022 at item number 9. Came to the considered opinion that as the post of the deputy secretary within bracket technical and IT being a single category post, the post should be filled up through open advertising. Stop. The council in its meeting held on 31/3/2023 at item number C dash 149 oblique 23 oblique 01 oblique 9. Declined the case of the petitioner for promotion to the post of deputy secretary within bracket information technology as the revised service regulation does not permit promotion to such posts as it was a single category post. Stop. Being aggrieved with the decision of the council in its meeting held on 31/3/2023. The petitioner is before this court by way of the present petition. Mr. S.K. Talukdar and the counsel for the petition submits that under section twenty-four, or is it 24? Yeah, it's under section 24 of the Assam Higher Secondary Education Act 1984. The council that section provides that the council may, subject to the approval of the government, make regulations for the purpose of carrying out the provisions of the act. And in this proviso, and the proviso also provides that all regulations, alterations, and revocations thereof shall be subject to the approval by the government and published in the official gazette. Stop. He submits that the revised service regulation under which the council in its meeting held on 31/3/2023 declined to give permission. Declined to give permission for promotion to the petition has not been approved by the government nor published in the official gazette. Stop. And therefore, on the basis, and therefore the case of the petitioner would not have been rejected on the basis of a non-existing regulation. Stop. Practically, that's your case, Talukdar?
My lord, basically this is my case. And in fact, I have also relied on, my lord, section, my lord, 19, which says, my lord, that when a decision is taken by the council, the chairman is duty bound, my lord, to implement the same.
He also places reliance under section 19 of the Act of 1984, which provides that the chairman, that it shall be the duty of the chairman to see that the provisions of the Act and the regulations made under it are faithfully observed, and the decisions of the council are fully implemented,
Yes.
are duly implemented. And he shall have all the powers necessary for this purpose.
And in this connection, my submission is, in the teeth of section 19, I could not have been allowed to operate, my lord, or to, my lord, serve on in-charge basis.
And therefore, when the council has taken a decision to promote the petitioner to the post of deputy secretary, what was it? Deputy secretary, information technology,
My lord. Now they say information technology.
to the post of deputy secretary.
Earlier in the, my lord, resolutions, they say,
Okay, information technology.
yes.
The chairman should have pursued the decision of the council and promoted the petitioner to the post of deputy secretary, information and technology. Stop. However, this has not been done, and therefore direction is required to consider the case of the petitioner for promotion to the post of deputy secretary, information. Stop. Mr. Nobadia, learned standing counsel for the council, while not denying the facts of the case, submits that what we were saying, that there's no post of deputy
The
secretary,
post does not exist in the earlier.
that the post of deputy secretary. Where was that? Page 90, yeah?
80. 80 or not.
80. That the post of deputy secretary within bracket technical and IT does not exist in the earlier regulation. And therefore, the issue of promoting the petitioner to the post of deputy secretary, technical and IT does not arise. Stop. He however submits that the revised regulation has not been given approval by the government till date. Stop. But I have considered the submissions forwarded by the learned council to the parties. Stop. But Rule 23 or 24 of the Act of 1984 provides, Rule 24 within bracket 1 of the Act of 1984 provides that the council may, subject to the approval of the government, make regulations for purposes of carrying out the provisions of the Act. Stop. The proviso to Rule 24 provides that all regulations, alterations, and revocation thereof shall be subject to the approval of the government and published in the official gazette. Stop. Para. The respondents have filed counter affidavits. Stop. At paragraph 5 of the counter affidavit. No, don't cancel it. The whole line. The respondent number 1, 2, 3, and 4 have filed affidavit in opposition in the present case. So, in the said affidavit in opposition, comma, at paragraph 5, it is stated that the revised service regulation has already been sent to the government for its approval by office letter dated 1/2/2022. But no communication is received from the government in this regard. Stop. A bare reading of these statements made in paragraph 5 of the affidavit in opposition filed by the respondents 1, 2, 3, and 4 clearly indicates that the government approval with regard to the revised service regulation is yet to be given and yet to be given. Stop. Therefore, comma, yet to be given. Yet to be given. Stop. It is only after the approval of the government is given and the same is published in the official gazette. The respondents would be in a position to follow the new revised service regulations. However, comma, in the instant case, the council in its meeting held on 31/3/2023 relied on the revised service regulation, which is yet to get its approval from the government, and thereby rejected the case of the petitioner for promotion to the post of Deputy Secretary, Information Technology. on the ground that it is a single cadre post under the revised service regulation. Stop. The action of the council, the action of the council in rejecting the case of petitioner on on the basis of a non-approved service regulation, non-approved service, revised service regulation. Is not in terms of the requirements of section 24 of the Act of 1980. Stop. On this ground, the decision of the council to deny the petitioner promotion to the post of deputy secretary within bracket information technology stands vitiated. Stop. The ground taken by the learned standing council for the council that the post of that is no post of deputy secretary within brackets information and technical and IT has been taken note by this court. Stop. It is to be borne in mind. Where was that abolition?
Yes. Upgradation, your lordship will find at page, my lord, 72.
No, the first resolution.
First resolution, your lordship will find at page, my lord, 67. This was creation. Yes.
No. It is to be borne in mind
68.
that the council in its meeting held on 30/10/2017 under item number 8 within bracket A decided to upgrade the post of academic officer within bracket academic dash computer to the rank of deputy secretary within bracket technical and IT. Stop. Further, comma. The administration committee of the council in its meeting held on 21/3/2018 recommended that the petitioner be promoted to the post of deputy secretary, technical and IT, and the post of academic officer within bracket computer be abolished. Stop. Further, comma. The council in its meeting held on 29/3/2018 resolved that the petitioner resolved to promote the petitioner to the post of deputy secretary within bracket technical and IT and the post of academic officer within bracket academic dash computer be abolished immediately after his promotion. It was only thereafter that the order dated 30/7/2019 was issued by the secretary of the council, placing the petitioner as in charge deputy secretary within bracket technical and IT. Stop. By the order dated 30/7/2019. Stop. Therefore, comma, when the petitioner was placed in charge, was placed in the IT section as in charge deputy secretary, technical and IT. The academic, the post earlier held by the petitioner, namely academic officer within bracket academic dash computer, would stand abolished. Stop. Therefore, comma, the contention of the Learned Standing Council for the council that there is no post of deputy commissioner, deputy secretary, technical within bracket IT is not acceptable before this court. Stop. But in terms of the discussions made here and above, comma, this petition succeeds. And accordingly, the resolution, the minutes of the minutes of the council held on 31/3/2023. Insofar as it regards to item number C-149/23/01/9. This holding will have to go, isn't it?
Yes, entire thing has to go. That item has to go, man.
Are set aside in cost. Stop. The matter is now remanded back.
My lord, my submission is that appointment letter has already been issued, 37/2019. So only they are required to issue a substantive order from that date and no other consideration, my lord.
Set aside in cost. Stop. As the respondents have already issued the order. Where is that order?
The page 78, my lord.
Dated 37/2019. Placing the petitioner as in charge deputy secretary, technical and IT, comma. The respondents are directed to issue a substantive, to issue an order permitting the petitioner to hold the substantive post of deputy secretary within bracket, what is it?
Information technology, my lord.
Information and technology. After following the due procedure of law.
Yes. Well, that will be done within a period of 3
Such
weeks.
exercise be done and completed within a period of 1 month.
1 month, my lord, 1 month.
1 month from the date of receipt of a copy of the order of this court.
Obliged. Deeply obliged.
Is allowed? No problem. I'm keeping a copy of this.
Yes, yes, Lordship, we keep
We
it.
have to refer to.
Yes, yes, correct. Obliged.
Obliged.
$25.
May I please? I am appearing for respondent of 5, the principal of the college, my lord. So I may be allowed 3 weeks time to file our affidavit. I have recently filed my wakalat.
You're appearing for the first
My
time?
lord.
My lord, I have some prayer, my lord. My lord, I have no objection if my lord kind of file an FIR. My lord, my lord reply. Only at this stage, my lord, that there is the dispute is with regard to some, my lord, leave salary of the petitioner. Petitioner retired in 2022, my lord. He is a kidney patient. His third stage of kidney patient, my lord. He is now, my lord, only my prayer is that let but the dispute with regard to leave salary may be leave open. I have no objection on that, my lord. But my other, my lord, benefits, my lord, some benefits, suppose like, my lord, the promotional benefits of the petitioner, those may be released.
That is not the subject matter of, I have seen the prayer, my lord, that is not the subject matter of the presentation.
That's why, my lord, those may be released, my lord. I have no, those may be released and the leave salary may be kept in, my lord. That may be heard. That is.
He is confined with the
Leave salary.
leave salary in this case.
So leave salary may be, my lord, kept in pending, but my lord, the other benefit may be
Okay,
released.
let him file his affidavit.
Yes, yes.
J. Payang Learned Council for the petition.
But pendency of this writ petition may not be barred for the release of the other benefit of the petitioner. That may be observed. Because otherwise they are not released.
Mr. P. Hazarikal and the council enters appearance on behalf of the respond number five and praise for
3 weeks.
3 weeks time to file counter affidavits. Praise the Lord, list up for 3 weeks. Pendency of this writ petition shall not be a bar on the part of the respondents
To release other benefits.
to release the other benefits
Which is not subject matter of this.
Yes.
which are not the subject matter of the present writ petition.
I'm a blame.
My lord, may I please, my learned friend may also file an affidavit because this is not mainly not related with the matter. Principal has no role. In fact, it is
You
the
say, Mr. S. Das, standing counsel, higher education also has a, also praise for. Or you say so and so, and so and so, praise for so and so.
only one line, my lord. The subject matter is with relate to my lord, leave salary. That may be indicated. Otherwise,
Pendency of this writ petition shall not be above for the respondents to release the
my lord, other benefit except the my lord, leave salary of the petition.
to the petitioner.
Except the leave salary, my lord. Leave
Except
salary is.
the salary which is in dispute in the present. writ petition.
Yes.
26.
Make please, Your Lordship. My lord, in this case, Lordship, already heard. I pray, Your Lordship, I may be allowed to submit my written submission, Lordship, within 2 or 3 days, Lordship. And serve the copy of the same to her, Lordship.
This was once.
Regarding
It's already
JNB
heard,
admission.
Your Lordships have already heard it extensively on the admission matter. And I had demonstrated that he had applied under the OBC quota. And he does not even have the OBC, the child does not even possess the OBC
Yes, yes.
quota. The advertisement was issued on 2nd of January 2023, Your Lordships, for the admission of 23-24. And his name came out in the third waiting list. Under the OBC category, he was selected. He had applied under the OBC category. And the list came out in the month of December 2023. And till 10th of January 2024, on which day he has filed the writ petition, he had not even applied for the OBC certificate. Your Lordships. So
You want to submit your written argument?
Lordship. And apart, Lordship, at the time of submission of application, Lordship, so I want to bring something, Lordship, on the record. As per record, I have verified the same, Lordship.
No. On your written argument, you can't bring in fresh records.
No, nothing. Within that, Lordship, nothing.
Because you
Lordship,
give a copy
already,
of-
Lordship, I'll submit because it will take
Okay, on request made by Mr. K. Majumdar and the counsel for the petition. When do you want?
within 1 week, Lordship, I'll submit on Friday.
since Your Lordships have already heard the matter.
Already
perhaps,
had the
Your
matter,
Lordships,
Lordship, because
No,
I'll not
please
lengthy
let me
down
get
that.
it.
Within 2-3 days, Lordship, I'll submit it.
Within the period of 1 week you want?
Yes, Your
Lordship,
Lordship.
When do you want? Fourth?
Third,
On-
4th June, yes, Your Lordship.
on,
As per Your
it may be on
Lordship.
Then
second.
you can also
Let
submit.
him file it by Friday, Your Lordships, if he can. Today's Tuesday. Let him
Because-
file it by Friday so that I get a chance, and by Tuesday, if required, I can file whatever is required to be filed. Otherwise, my affidavit in opposition is very clear,
Lordship,
very categorical, and all my entire grounds are already comprehensively be dealt with in my affidavit in opposition. So let him file it by Friday, Your Lordship,
You file by Friday?
by
Lordship.
31st,
Lordship, it may be by Friday, Lordship.
and fixed for Tuesday, next Tuesday, fixed for.
No, I'm sorry. On 4th and 5th, Lordship, I will be out of station, Lordship,
Third, Monday,
because I will go to Silchar.
Monday. Monday, Thursday,
It may be fixed on 7th, Lordship. Is it part of Lordship? I'll submit it within by Friday, Lordship. It can be finished up. Lordship.
Okay, then cancel the order, Mr. K. Majumdar and the counsel for the petitioner.
Yes, today,
Praise for some time to enable him to file
written
arguments.
submission, Lordship.
Written
Written argument, Lordship.
arguments. Praise a lot. Let such written argument be filed on or before 31st May 2024.
Lordship.
List the matter on 7th of June.
if you're right.
Much obliged, Your Worship.
31.
In this matter, I need weeks time to file the FTP.
Counter affidavit.
Counter affidavit. 5 cases are.
My lord,
developed.
they have been given repeated opportunity to file affidavit, but till that they have not filed. Again, they are coming with the plea that they want to file affidavit. My lord, in this case, my lord, some actions, I am a student. Actions has been taken by me, by the disciplinary committee. And in the incident, there was no involvement on my. I have nowhere involved in the incident, but I have been punished without any, even in prima facie case against me. They have just abruptly given management to some people, for some students. So they are not being able to justify the action, their actions.
Why are you not filing your?
Unnecessary delay,
In the meantime, they have filed IA to appear in the examination. We are, by virtue of the honorable court order, they appear in the examination also. So,
Again, new session will start, my lord. Again, new
Heard,
session.
Mr.
S. Sharma.
S. Sharma, learned counsel for the petition. Mr.
S. Sutradhar.
S. Sutradhar, learned counsel, standing counsel.
Yes, Lordship, I to guard.
For the response number?
225, Lordship. In all cases.
Learned standing counsel, Indian Institute of Technology.
Technology guard.
Price for how much time?
2 weeks time, Lordship.
Are you sure?
Yes, yes, Lordship.
You file it by 2 weeks.
My lord,
Because
2 weeks will be 2 weeks will be too much, my lord. They have received instruction long back. They have appeared before the long back. They have issued. Let it be 1 week.
Okay.
Let it be 1 week, my lord. Let it be given in 1 week, my lord.
Please allow. This is the matter after 2 weeks.
My lord, one date may kindly be given, my lord. Specific date.
Give a date after 2 weeks.
14.
Observe.
32.
May it please, Your Worship. The matter pertains to withholding my pension, regular pension, my lord, after 18 years. Now, on the last occasion, this honorable court observed the urgency and directed them to either produce the records or file the affidavit. And that affidavit has been filed today morning. I need 2 weeks time to come up with a reply, my lord. My only prayer today is, my lord, if a date is fixed and if your lordship kindly observes that the consideration of the interim order is also left open on the next date, my lord, as it was done on the last occasion.
Record is also with me, Lord. I'm ready with the record also. Mr. S.C. Cal. Then it's standing counsel, Tezpur University. Submits that he has filed counter affidavit. Already filed copy this morning.
Yes, yes.
Copy has also come to the court. Huh? It has come to the court. Look, this morning. Stop. Mr.
P. Bharadwaj.
P. Bharadwaj, learned counsel for the petitioner. Praise for
2 weeks, man.
2 weeks time to file reply to the counter affidavit filed by the respondents 1 to 5. Praise hello. You want a date fix or what?
Yes, my lord.
List on
My lord, let it be on 11th, my lord, June.
11 June. Now, the prayer for entry shall be considered on the next.
Much obliged.
33. Hearing.
And therefore, my lord, lordship may fix a date, my lord, in this matter, my lord. Today it will also not complete. One go it can be completed, my lord. As for unauthorized absence, my lord, punishment imposed dismissal from service. I was relying on a decision to Sanbi Parmar. And there is another more decision has come up, my lord, in an unauthorized in a case of unauthorized my lord, absence in service, dismissal is bad. That judgment hall has in the meantime come, my lord. I will place that. Due to power cut, I could not get the copy, my lord. In the case of R.K. Sharma, my lord. Thursday or next Friday, my lord.
Okay, due to paucity of time,
Yes.
this case could not be taken up. Accordingly, list down.
Friday, Friday, 31st. My lord.
31st.
Obliged.
34.
My lord, this is also a part-heard matter. My lord, today perhaps it will not be possible.
And regarding that professor, my lord, age of superannuation, the respondent, they were supposed to produce the cabinet memorandum. My lord, can it be taken up on a hearing date next week? And lordship, one aspect is that, my lord, this matter is yet to be admitted. It has come in the hearing column. Can it come in the admission hearing stage, my lord, on a next date, my lord?
How is it coming for hearing?
My lord, maybe due to some mistake on the part of the registry, my lord. Can it be on 4th of June, my lord?
No, 1 minute. Okay.
On 4th, my lord, in the admission hearing stage. Because they will produce only a cabinet memorandum, my lord. Otherwise, lordship has already heard the matter. On that day, I'll just refresh I'll not take much time, my lord.
But Mr. T. Chakrabarti, let it also. Also heard Mr. PG Saikia. The government advocate, Assam. Rule has not been issued in the present case. Accordingly, list is matter in the admission column on
On 4th of June, my lord, in a hearing day, Tuesday, my lord. I'm deeply obliged.
35, 36.
May please, your lordships. My lord, it's a hearing matter, my lord. Senior counsel Mr. I. Chaudhary will appear in this matter. May I pray that this matter may come up on 13th of June, my lords? 13th of June.
This is a part-heard matter.
No, my lord, it is not a part-heard matter, my lord.
Then why is it shown as part-heard?
It is reflected as a part-heard, but it is not a part-heard matter, my lord.
On request made on behalf of Mr. I. Chaudhary, the senior counsel for the petitioner, list the matter on 13th.
13th of June, my lord.
13th of June. Stop. This is not a part-heard matter. Accordingly, registry is directed to make corrections in the process.
Deeply obliged.
37. Thirty-seven.
Respondents, anybody appearing? None appears for the petitioner. Mr. PG Cycle and the government advocate appears on behalf of the respondents. This. The matter even on 6. It's a part of matter. Yeah.
Item number 38.
38 is not clear.
And it is after, based on the 4th of June, lordship.
The all pending matter, Lordship.
Mention in the model.
Already mentioned.